Yes, in the beginning, like we always do.
Okay, good morning, everybody. Thank you. I look forward to working with all of you. This is a very exciting program that the State Bar is putting on. I appreciate your willingness to work on the task force. We're going to start with a roll call. Mimi, you want to begin?
Okay. Justice Edmond?
Here.
Toby Rothschild?
Here.
Joyce Brady?
Here.
Andrew Arruda?
Here.
Barbara Arceda?
Here.
Tara Bird?
Here.
Judge Wendy Chang?
Here.
Abhijit Chauhan? Jean Clausen?
Here.
Valerie Dean?
Here.
Margie Estrada? Lori Gonzalez?
Here.
Bridget Grammy?
Here.
Andrew Kuchera?
Here.
Joanna Mendoza?
Here.
Kevin Moore?
Here.
Heather Morse?
Here.
Daniel Rice?
Here.
Alan Rodriguez?
Here.
Daniel Rubens?
Here.
Mark Tuff?
Here.
Joshua Walker?
I'm going to do the other people too.
Okay, that's it. Thank you.
And is there anyone on the phone, Mimi, that needs to be identified?
I don't know. We will not.
This is Teresa Schmidt from Los Angeles.
Teresa, welcome. Anybody else?
Thank you.
Okay, hopefully you all have your agendas. The first item up is an oral report, and I really have no oral report other than to say welcome. I know that we are all aware of the huge unmet need that there is for legal services, and I really look forward to this effort to explore whether or not there are changes that can be made to our ethics rules to improve access to legal services. I had an opportunity as we were putting this committee together to go through and review each of your bios, and what an amazingly talented, creative, accomplished group this is. So I really look forward to working with all of you. And I really thank the Chief Justice for her interest in this topic and the State Bar for taking it on. You will see as you work over the months on this project, the staff at the State Bar is really a remarkable group of people who work so hard and will keep us all on track. And so I look forward again to working with all of them as well. So what we decided we would do is start by going around the room and just very, very, very briefly, if that's possible, introducing ourselves. Just talk a little bit about what you do, and if we can keep it literally to a couple of minutes, we'll be able to get on with what is a large amount of work that we have to accomplish today. But we do want to make sure that as part of this process, we really get to know each other. So before we go to introductions, Randy, is there anything you wanted to say?
I want to introduce myself. I'm Randy Fantorn. I'm with the State Bar's Office of Professional
Trying to
Competence.
pull together some washing. But
The Office of Professional Competence will be your primary staff support.
pull together that.
But among us from the State Bar staff this morning are also Leo Wilson, who is the CEO of the State Bar of California, and Donna Herskowitz, who is the Chief of Programs who oversees the Office of Professional Competence, and will be the primary person our line to the Board of Trustees as the work of the task force goes forward. And I actually wanted to give an opportunity to Leah and Donna if they wanted to make any sort of introductory welcoming remarks.
Leah and Donna, before you begin, let me just ask the folks on the phone if you could each be sure to mute your phones. We're getting some feedback both from the movement of papers as well as actually hearing some voices. So if you can mute your phones, that would be very helpful. Okay, Leah.
Thank you. I don't want to make any extensive remarks other than to mirror Justice Edmonds' appreciation to all of you for coming together, and to just briefly share an anecdote. Yesterday I was in Sacramento meeting with a number of legislators, and I shared a fact sheet about this project. And everyone universally was really interested in the initiative. But I had one who I think was particularly candid, and he said to us, wow, I can't believe the State Bar is doing something so innovative without being forced to. I just think that really symbolizes the culmination of work, the hard work of our board, the leadership of the court, and really kind of transforming this organization and turning it into one that is able to be forward-leaning and really to think meaningfully and deeply about how can we make real our commitment to access to justice. Also, really wanting to thank Justice Admin for agreeing to chair this task force. You may not all be aware, but she just came off a stint of rather extensive leadership as related to the revision of the rules of professional conduct. And so I think when the court asked her to take this on, she could not say no, but we are extremely appreciative because we know this will be quite a bit of work as well. So thank you.
Thank you. And I really have nothing to add to all of those great remarks, but it's very rare for me to pass up an opportunity to say something. So I just will once again welcome all of you and thank all of you for your participation in this. We have an ambitious schedule ahead of us. And watching the way Justice Edmond ran the Rules Revision Commission, we will be incredibly productive. Yes, we will be incredibly productive over the course of 2019, and I know we will make our goal of really sort of delving into this topic in a really thoughtful way and being incredibly innovative on the way that we can increase access to justice through innovation and technology, and at the same time, always remember our mission to protect the public. So thank you again. You will see me at many, many, many of the meetings that we've got over the next year, and I am really glad to be able to support all of you in this effort. We're happy that we will be seeing you. One final word before we actually go around and introduce ourselves. One of the great blessings, in my view, in serving on this task force is the fact that we have a liaison from the Supreme Court. Greg Fortescue was our liaison also on the Rules Revision Commission and was quite an asset to all of us and a wise advisor. So we are thrilled that you're here, and let me just open the floor to you and see if you have some comments you want to make.
Thank you very much, Justice Edmond. It was fun to see a lot of the members of that Rules Revision Commission this morning. We felt like we were getting the band back together in some ways. And normally I would say, the topics that we're going to cover, I can't really say that the court has formed an opinion on some of the discussions, but I think this is a different area. I think there are certain members of the court that are very interested in this topic. And access to justice is an issue that's near and dear to the Chief's heart and several members of the court as well. And this is a unique way for us to take on that issue beyond just funding and trying to find better ways of using the limited funding we have to allow to bridge that justice gap. We just came out of this 2-year process of a wholesale revision of the rules revision, the rules of professional conduct, and you would maybe think, well, why revisit these rules? Why reopen them? I think it's actually a perfect opportunity to do it in this context because we really have taken a hard look at each of the rules that were adopted on November 1st, and we have a really good platform as a court of where we stand in terms of our ethical rules in this state. And so I think it's a perfect opportunity to try to find that balance between protecting the public through the ethical rules that we impose upon lawyers and finding ways in which we can open up the availability of legal services to those who can't afford it in the state. So I'm really looking forward to meeting everyone and hearing their views. I said I think at the end of the Rules Revision Commission, I felt like I just went through a 2-year master's class in legal ethics. And I feel like now I'm going to go through another master class. So thank you for letting me sit in on it.
Thank you so much for being here. And we also have 2 wonderful co-chairs, Toby Rothschild and Joyce Raby. Let me ask you if you want to say a few words to the group.
I obviously do not have any prepared remarks. And as a technologist, I think it's always fun to be in a room with, this will sound a little disingenuous and I don't mean it that way, but it is always fun to be sort of in a room with a group of people, especially lawyers, because you have such different perspectives on the work that we do. And I always find it kind of fascinating to have that interplay and that debate. Because we're both looking at it from very different perspectives. And I was just looking around the room and really pleased to see so much diversity in this room, and also in terms of the kind of skill sets and experiences that people are bringing to the table. This is my first opportunity to work with the California State Bar, and I'm very excited. Having done work with both Colorado and Florida, I'm really excited to see what we can do here in California. So.
And I guess I would take a slightly different view because I've been working in one way or another with the State Bar of California for the last, well, since about 1976. I've been on one bar committee or commission or task force or another pretty much consistently. So I find working with the bar really a quite effective way of getting a lot done. And access to justice is where I come from, so that's the perspective that I bring, and trying to find ways to make that work better is really important. We appreciate all of you coming in from wherever you may come from to help accomplish this.
Terrific. All right, now let's go around the room and hear from folks. Randy, why don't you start, and we'll include the State Bar staff in the discussion.
Randall Diefenchorum, you can call me Randy. I'm with the State Bar of California's Office of Professional Competence. Office of Professional Competence, it's not the enforcement, it's not the disciplinary part, it's not the admissions part of the bar. It serves a very specific role in terms of having responsibility for the professional responsibility standards. We have, for example, the Ethics Hotline program, which is a research telephone service for lawyers who have questions about professional responsibility. And we assisted Justice Edmond and the Rules Revision Commission on the project everyone's just been talking about. So we're looking forward to another similar, productive, and challenging project with this one.
Hi, I'm Minnie Lee. I'm with the Office of Professional Competence as well. I've been here almost 12 years, and I staff the Ethics Committee as well as the Rules Revision Commission, and I will be one of your point people on this project as well.
Good morning, everybody. My name is Andrew Tuft. I've been with the bar nearly 10 years, and primarily the staff attorney in the Office of Professional Competence. However, for the last 4 months, I've been acting as the interim program director of the Office of Access and Inclusion, which is the office in the State Bar that's primarily tasked with the grant making and policy work of providing legal services to the needy in California. And I too was staffed on the Rules Revision Commission, and I'm also the primary staff person for the State Bar's Committee on Professional Responsibility and Conduct. And I love ethics, and I'm really excited to work with you. So if you have ethics questions, we can talk all day. I'm your guy.
Hi everyone, my name is Brady Dewar. I'm Assistant General Counsel in the State Bar's Office of General Counsel. My work, I typically staff most of the bar's access and inclusion activities, and I've been asked to work with this committee. I will also be the staff liaison for the subcommittee on UPL and artificial intelligence. I've been with the bar about 8 months, and my background's in civil litigation, so I have some experience and interest in modern technology, and I'm really looking forward to working with all of you. Thank you.
Good morning, my name is Dawn Nguyen. I'm a program supervisor in the Office of Access and Inclusion. I normally staff the Legal Services Trust Fund Commission and the Access Commission here at the State Bar. I look forward to providing staff support to this task force and also bringing an access perspective for my work. Before I came to the State Bar, I was the legal aid attorney for about 8 years. I'm Margie Estrada. I'm the Chief Counsel at the Senate Committee on Judiciary.
I'm Heather Morse. I'm the Director of Marketing and Business Development at Greenberg Lusker, a law firm down in Los Angeles. I'm also a writer and blogger on the business of law issues. And this is one that's near and dear to my heart, and the greater legal ecosystem out there is watching.
My name is Bridget Grammy. I'm the Director of the Center for Public Interest Law at the University of San Diego Law School. And I teach a class on public interest law and practice, so I'm thinking about this from the perspective of future lawyers. And also, we do a lot of advocacy work with the State Bar on a lot of reform efforts. So I'm very excited to be part of this.
Hi everyone, I'm Joanna Mendoza. I sit on the Board of Trustees at State Bar. I consider this task force a culmination of some years of reform that we've gone through to take the organization from an attorney-centric organization to a public-centric organization, and very excited to be here and be part of this. I heard some concerns that this is just another task force. We're just going to have recommendations and we're not going to go anywhere. I can assure you, the board is very committed to this. The State Bar is very committed to this, and I see action at the end. So I'm very hopeful and very excited, and thank you all for applying and for being here.
Hi there, I'm Dan Rubens from a company called Legal Robot. We do automated contract review, turn legalese into plain English. AI.
Good morning, I'm Mia Ellis with the Office of Chief Trial Counsel based in Los Angeles. I'm a manager. I've been with the bar for about 10 years, and I'm very excited to be here. Thank you.
Good morning, my name is Valerie Dean. Am I on? I don't know. I have a company called Technotaries. Well, so this is very exciting for me because we provide virtual legal services to attorneys. I also am very involved with various bar associations, chairing and co-chairing diversity committees, so I'm very happy to be here and be involved with this process. I don't know if it's on. There you go.
Good morning, I'm Barbara Arcedo from the Contra Costa County Bar Association, and I've been the director of the Lawyer Referral and Moderate Means programs there for the past 10 years.
Hi, I'm Dan Rice. I'm co-founder of a company called SageWise, and our focus is actually smart contracts and handling dispute resolution around that technology.
Good morning, I'm Mark Tuft. I'm in private practice. I represent lawyers and law firms, and I've on a few commissions for the State Bar over the years. Co-author of the Wetter Group Practice Guide on Professional Responsibility, on various committees, the ABA, and involved in the law governing lawyers for about 50 years.
Okay. I'm Kevin Moore. I'm a professor at Western State College of Law. I teach contracts, professional responsibility, law practice management. I recently ended a long sojourn on the Rules Revision Commission, where I was the consultant, and at the end of it, I was a member of the commission.
Before you speak, let me try one more time. If I could ask the folks on the phone to please mute your telephones. We're getting a lot of noise here, and it's very difficult for us to hear. Okay, if you could mute your phones, it would be very helpful. All right, thank you so much.
Good morning, I'm Jean Clausen. I'm with a company called Arog. It's an international insurance company, and I'm a legal industry advocate, which means I foster our relationships with the state bars, different access commissions, and we really focus on the modest means individuals and helping connect attorneys and educating citizens on how to get legal help. So thank you for allowing me to be here.
Hi, Alan Rodriguez here, founder of 1400. We are a law innovation consultancy that develops software and digital experience solutions exclusively for the legal industry. One of the projects, or some of the projects that we enjoy most, are those that leverage technology to create more equitable distribution of legal services. So very excited to be here. Thank you.
Hi, I'm Lori Gonzalez, snarky paralegal turned snarky entrepreneur who usually yells at lawyers and techies at the same time. So really excited to be here. I've been a part of Tennessee's Access to Justice Pro Bono Committee for many years. Actually, on the underneath level since it started. So I find myself right in the heart of what's possible, all the cool AI tools, and what all of the law firms are actually doing, which is faxing in handwritten forms. So I'm interested in how we can help shape that up. I'm really excited to be here.
Hi, everyone. My name. Sometimes I don't need this. Hi, everyone. My name is Andrew Ruda. I started a company called Ross Intelligence. Myself and my co-founder saw about 3.5 to 4 years ago that modern artificial intelligence technologies would begin to shape every industry, and particularly the benefits it could bring to the legal space. So we might have been part of the problem with a lot of the hysteria about us all losing our jobs, which I think is more media than truth. Access to justice is truly very foundational to myself. We started the company with the vision that technology would be able to scale lawyers so that more people would have access to the law. So I'm happy to be here. I speak internationally on legal innovation and the future of our legal space, and I think I get to be a citizen of the world, and I get to work with bar associations across the globe, and I'm really interested, and I know someone mentioned that the legal world watches on, and I know that I've been told a bunch of things that folks want to get shared, and a lot of people are looking at us and seeing what we're doing as particularly innovative, and I hope that we can offer a way for others to kind of mimic what we're up to and continue this trend and lead the way.
Thank you. Leah Wilson, again, Executive Director of the State Bar.
Donna Hirschkowitz, Chief of Programs here at the State Bar.
Hi, I am Judge Wendy Chang, and I sit in the Los Angeles Superior Court down at the Mosque Courthouse, which is in downtown Los Angeles. Prior to my appointment, I was like Mark. I advised lawyers and I defended lawyers, and I worked with them for a little bit. Since then, I am now assigned to a limited civil jurisdiction courtroom in LA. So I saw all of these substantive issues from the lawyer's perspective, and today, a very large amount of people who come through my courtroom, they are self-represented. Sometimes there are people who come in, they say they are attorneys in fact. So I see the people who come in who try to be I see all of this play out at a very, very real level. And so I'm really excited to be here, and I'm really hoping that we can do some good work.
Good morning, I'm Tara Bird. I'm a probate trust and business litigator in San Diego. I was also involved in the California Lawyers Association transition away from the State Bar sections. I'm currently on the Marketing and Communications Committee and led the committee that decided that we should join up with FastCase, which will help us offer innovative legal research services to all of the CLE members, which I think is a great step in the same direction that we're all going here today.
Good morning, my name is Andy Kashara. I'm a professor at San Joaquin College of Law in Clovis, which this morning was about a 4.5-hour drive from here. That's a suburb of Fresno in the Central Valley. I teach remedies as well as a couple of different practice classes, including legal technology, community lawyering, and a new class called Practice 99, which teaches law students to start and grow independent law practices serving low-low clients, mostly in rural areas. And so this type of work is something that I've been interested in and doing and teaching for a while, and I'm very excited to be here.
Hi, good morning. I'm Laura McCurdy. I'm the program supervisor for the Office of Professional Competence that is tasked with supporting this group, and I will be coordinating the administrative side of the support, and also will be interfacing with one of our staff who is not here, is holding down the fort back in the office, but Angela Marlaud. The two of us will be your contacts for travel-related guidance, travel reimbursement questions, roster updates, or communications of that nature. So please don't hesitate to call either of us if you have any questions or need support.
Greg Fortescue, lead staff attorney for the California Supreme Court.
Tony Rothschild. I'm retired after 45 years at the Legal Aid Foundation of Los Angeles, and now as a volunteer, I do ethics training and consulting for legal aid programs throughout the state. And I've been on the Access to Justice Commission for essentially 25 years since it started. And I was on the Rules Revision Commission, so I have both the ethics and the legal services side of the activities here. So I'm looking forward to how we put those two together with the technology side and make it work for everyone.
And I'm Joyce Raby. I'm the Executive Director of the Florida Justice Technology Center. We are a statewide nonprofit dedicated to using innovative technology to decrease the justice gap. And so there are a couple of people, I've been making notes of some of you tech guys who are not going to get out of the room until I've had a chance to talk to you. But we have created a couple of tools. We work obviously very closely with the legal aid organizations and with the Florida Bar and the Florida Bar Foundation, the IOLTA funder in the state of Florida.
Thank you so much, and I'm Lee Edmond. I am the presiding justice of Division 3 of the 2nd District Court of Appeal in Los Angeles. So I sit downtown in Los Angeles. And I am absolutely delighted to have the opportunity to work with all of you. And I am also so impressed we are ahead of schedule. They said, go around the room in introductions, that'll take hours. It's a wonderful job. As you'll find out, there are certain things that we need to do at the beginning of each meeting, and one of those is to ask for public comment. So I'm now going to open the floor to find out if there's any member of the public here who intends to give public comment, either here live or on the telephone, that wants to make some public comment before we begin. Okay, hearing none, I'm going to turn to Randy and see if you have a report.
We wanted to just mention briefly the staff support that's coming through the Office of Professional Competence. They have their liaisons, and I think Lauren began a little bit about that. And I think there's a good opportunity to put some names to faces as we go forward. The administrative side, you'll get used to it after the first couple meetings.
Sure. The administrative team, well, as I said, I'm the program supervisor. But let me just give you a little bit of context to the Office of Professional Competence in terms of the State Bar. They're not discipline or enforcement or admissions. We're a small program that supports the State Bar's legal ethics and professional responsibility services. And we do that through an ethics hotline, telephone research service, through a number of publications that we generate, a lot of website resources on legal ethics and professional conduct, and staffing of the ethics committee that is the Committee on Professional Responsibility and Conduct, or COPRAC. You'll probably hear about them from time to time. And in particular, the draft or the advisory ethics opinions that they publish. In addition, we supported the effort to, all efforts that relate to the revisions to the Rules of Professional Conduct that recently culminated in the work of the Rules Revision Commission that you've heard about, and resulted in rules that were adopted by the board, approved by the Supreme Court, and went into effect November 1st. So we're working on seeing those to fruition and getting and educating the attorneys on those. And so it's through all that background that our office came to be assigned to the work of this task force. And our team is led by Randy. Randy will be guiding the ADL's leadership team, as well as the administrative staff to support this effort throughout, and we'll be attending all the meetings. And then there is Andrew Tuft, who's the staff attorney for the Office of Professional Competence. He will be providing legal ethics research and guidance and input as needed throughout. And then Mimi Lee, you'll see also at all the meetings, providing technical support, projecting resource materials, also gathering research materials and posting them on a shared Dropbox folder that she'll tell you about a little later, so that you can have the tools you need. And then there is myself and Angela Monroe that I mentioned earlier. I think that is all I intended to say. Randy, is there something else?
And just so that you have like a cheat sheet, as we're going forward with this project, if you're wondering, I don't know how this works, Randy, aren't we ever going to get input from outside of our group? Is there going to be any sort of public comment or survey or anything that we're going to do? If you have questions about the project plan, how we're going to get from start to finish, talk to me. I'm working closely with Leah and Donna, and I should be the one to get you answers for how we're going to complete this project. If you have a question about a professional responsibility, a legal ethics topic, I think Andrew said he's your guy, and so there's going to be a lot of talk about rules. And if your question is, well, why is there a rule on advertising, also a rule on communication, and then another rule on direct contact solicitation? What's the difference? And those are all fair questions, and Andrew will talk to you about that. He can help you with that. And Mimi, when we get to the point where we're actually doing presentations from the subcommittees or the subcommittee leadership, or we're trying to work on actual drafting proposals on screen, Mimi is our in-house tech guru that's going to help us pull that off. And she can also help you with any of the communications among the task force as well. We require that if you want to communicate with the task force, you really go through staff. Either send it to Lauren or send it to Mimi, and then we will turn it around to the rest of the group. And there's reasons for that will be explained shortly. But that's sort of the cheat sheet. Talk to me about the project. Talk to Andrew if you have questions about the legal ethics aspects, and Mimi about how we're going to pull off accomplishing some of the things at our meeting itself. I'm sorry to say that State Bar staff does not have a tech AI guru, but that's why we enlisted many of you. So by the same token, you coming to us for help, don't be surprised if Andrew, Mimi, or Randy doesn't come a calling saying, what in the world is blockchain? I have no idea. Please explain it in plain English. We may do that.
Okay, any questions of the wonderful State Bar staff? And you will find over time, dealing with them is really a pleasure. Okay, hearing no questions, talking to them is always safe. Talking to each other is not necessarily so. And fortunately, we have Brady Duerwick here with us from the Office of General Counsel, and he's going to talk to us just for a few minutes about some of the constraints that we are under in our meeting rules under the Bagley-Keene Act. So we're moving into the item B1. Brady.
Thank you, Justice Edmond.
So as members, volunteer members of a body that was created by the State Bar, which is of course a public agency, there are certain legal considerations we need you all to be aware of. I'm going to try and skim over some of the boring details because a lot of the details about meetings and how they're posted and the agendas we create, that's for staff to worry about and doesn't concern you. So I'm going to focus on your need to knows. Just as background, the Bagley-Keene Open Meeting Act applies to meetings of boards of public agencies. It applies to the State Bar, and it also applies to any advisory body of 3 or more people created by formal action of the State Bar. And in turn, because ATIL's task force has created subcommittees, it applies to those subcommittee meetings as well. Basically, the Bagley-Keene Act, its purpose is for the public's business to be done in public, so the public can have access to information about what we're doing. There are a lot of rules. The one that will most closely affect you is that before we have meetings of the subcommittees or the larger task force, we need to post agendas 10 days in advance. And then once we have the meetings, we need to stick to those agendas. With rare exceptions, we can't go outside of the properly noticed agenda items. A meeting is any time that a group, a majority of the subcommittee or a majority of the task force gets together to discuss items of business of the subcommittee of the task force. It can be virtual, so email chains would constitute a meeting and are prohibited.
a little bit more detail on that. A meeting, again, doesn't have to occur in one place to be subject to the Bagley-Keene requirements of an agenda and public notice. So a meeting is any series of communications of any kind, directly or through intermediaries, to discuss the business of the task force or the business of the subcommittee. It applies to emails, telephone calls, if one subcommittee member calls another subcommittee member, and so on and so forth, and then a majority of the subcommittee members have ended up talking about something, that would be a meeting, and because it wasn't posted and agendized, that would violate Bagley-Keene. So our tip for you to remember is that when you're not in a meeting that's been noticed and officially, that if you have any emails, that you keep them, you might be in a working group with one other person. So always, copy a State Bar staff comment, keep your emails to one other person, and if you need to send a group email, the way to do that is to send your message to the State Bar staff person who's staffing your subcommittee, and they can send out a blast email message with everybody on BCC so that we don't get into an unintentional situation where people are having a serial meeting by email. Any questions on that concept? It's a little strange. It was a little strange when I first learned about it a year ago.
Considering the room, perhaps you could apply that to social media as well?
Definitely. Take that one on the next slide. I will. I think it's my slide after that. If you make a post about business on social media, we would actually recommend that you don't do that because it creates a big risk if you're on LinkedIn or Twitter, and a number of other people on your subcommittee are. If they read that, and a majority of your subcommittee or this task force reads that, that technically would become a meeting. So we don't want you to do that. Bagley-Keene applies to teleconference meetings as well. The thing that you should be aware of, for the most part, at least our task force meetings are intended to be in person. If it does become necessary that somebody needs to attend by teleconference, for the members of the task force or the members of the subcommittee, Bagley-Keene requires that your location where you're going to be taking that teleconference be open to the public and be posted at least 10 days in advance. So if you want to attend a meeting but you can't make it to Los Angeles, you should contact the State Bar staff. We can make arrangements. If you can be in San Francisco, we can make arrangements for you to teleconference from here. We then have an open conference room where the public could then attend as well. If you wanted to do it in your office, that would be possible, but again, it would have to be posted 10 days in advance, and it would need to be open to the public.
And ADA accessible.
And ADA accessible, correct. Help drops is ADA accessible. Bagley-Keene also requires that, as we do today, that we have public comment periods at all of our meetings. And again, social media creates a risk of inherent Bagley-Keene violations and best to avoid. Bagley-Keene, the real risk here, although there is a possibility of when there are willful violations of civil or even criminal penalties, the real risk is that if business is conducted in violation of Bagley-Keene, it could be invalidated later. So it is somewhat serious, and of course we do want to follow the spirit and the letter of the law so that we can make all of our important conversations public. The other thing that you should be aware of, and in this one there's much less for you to do, is the California Public Records Act. Citizens of California, and in fact all people, have some constitutional and statutory rights to information about the business that we conduct as a public agency. So nothing for you to do again, but the thing to keep in mind is that your emails, to the extent that they are about ATIL's task force business, could be subject to a public records request. The pro tip here is whenever you are transacting ATIL's business over email, be sure to copy a State Bar staff person, because that way if we get a public records request, we don't need to go to you. We'll already have the information and you don't need to worry about searching your emails and the burden that entails. Again, public records are any written documents about the business that we do here. And all are subject to disclosure. And finally, we just wanted to make a few pointers about social media use, public speaking and press. Again, I think this is probably the fourth time I've said it, to avoid social media use about ATEL's business because of the risks that it creates. But it's important for everybody to keep in mind that ATEL's task force members are not authorized to speak on behalf of the State Bar, the task force, or their subcommittees. You, of course, don't leave your First Amendment rights at the door when you join this group, but we do urge you, when you are speaking publicly on behalf of yourself, of course, or speaking to the press on behalf of yourself, that you coordinate that to the extent you can and are willing to do so with State Bar staff. The State Bar, as everyone has mentioned, believes that this is very important work that we're doing here, and we'll be developing a communication strategy to complement our work. So if you have a press inquiry, if you want to make public statements or a speech about the work here, to the extent that you can contact either your subcommittee liaison or Rebecca Farmer, who's our Director of Strategic Communications, and at least talk that through to see if the strategy can align. That would be very helpful to, I think, the task force and the State Bar. So with that, there was a lot more detail on my slides. I'll put some handouts up on the corner, up on the counter if you want any more detail about Bagley-Keene or the Public Records Act, or see me after with questions.
Questions for Brady? We were having a side conversation over here. Joyce is out of state. If she gives notice that she's going to participate from some other state, does that comply with Bagley-Keene?
Because she's a member of it would be compliant. She would need to do so in a public area, whether your office or somewhere where, in the very unlikely event that a member of the public in Florida wanted to show up and participate, that they could. So.
Good to know. Thank you.
Any other questions?
I have sort of a general comment / question. I think there are a lot of us who are very heavily involved in social media, so thank you, Joanna, for making sure that this feels very different than how we have worked on some of these other committees, or I've been involved in State Bar things and Supreme Court things in Tennessee. Clearly there's some differing rules, and I think there's already a ton of interest publicly in what this is doing, so I expect and know that I've already had questions and comments, and I think some others here have had that as well. So I think more of a comment of, it would be helpful to have some general things that are okay to respond with, because certainly I've already liked a tweet this morning that might have got us in trouble. Sorry, guys. Just some general things. Will there be a set of things we can say or do in social media? Because I think the idea that no social media, we're going to get comments and questions. We're already getting those, text messages, emails. And so clearly making sure we stay in the rules, but is there some set of generic things maybe we can say or do?
I think Brady mentioned that we are working on a corresponding communications strategy, and there will be a communications point person on this. And so I think that's great feedback, because we aren't necessarily attuned to thinking about creating acceptable social media posts, but I think I'm making a note of that now. So certainly between now and the next meeting, we will have that solidified and in place and communicated to all of you about it.
And I think in the meantime, to the extent that that whatever your communications is not with the other members of this group, then you're not going to run into the Bagley-Keene problems. And again, if you're not discussing the business, what you're currently considering, had a very productive meeting with the ATEL's task force, that's not going to cause any problems. But I think until we get the more guidance on what exactly our strategy is, feel free to call me and I can bounce any questions off me, and I respond very quickly.
Brady, correct me if I'm wrong. You can take pictures of each one and say, hey, we're here. You can send out notification that the meeting's happening, because you're not commenting on the actual business of the meeting. So those are not a problem.
It's more that depending on what subcommittee you're on, if you have an assignment to consider something and you start talking about the substance and I'm thinking of going with this recommendation, what does everybody think? And then other members start commenting, and that's where the real problems arise.
That's very helpful.
Whew. I've been live streaming this whole thing.
That's okay, it was noticed.
I'm joking.
I really appreciate those comments, because I too have been contacted by folks from around the country and involved in the ABA, interested in these issues, and so, but these are great things to keep in mind, so Brady, thanks very much. Any other questions for Brady?
I just wanted to add one thing that sort of relates, and that is that, I mean, as you mentioned, this is being webcast. Whenever meetings are held in our two main conference rooms, they will be webcast, and you can direct folks that are reaching out to you that are interested to go to the State Bar's website and view that stream. There will be an archive of it posted, for about a week after the meeting. And then there will also be an option for folks to sign up or subscribe to meeting notices from the State Bar. And we will also, through that list, have the ability to reach out to that group of people that have subscribed and update them with, more formal actions taken. I know it's not, of course, the same or as fluid as social media, but these are going to be ways that they can sort of get the official word from the State Bar.
Lauren, can you say that again? Exactly what are we going to make available? It's a listserv, is that what it's going to be?
Yes, it's attached to the meeting, the committees and commissions meeting page, so that when you go to that page to see the State Bar meetings posted, there's at the bottom. And Ginny can real quick. Yeah, what do we have to do? Everybody is.
If you go to the State Bar's main website, which is calbar.ca.gov, and you go to the About Us section, you'll see heading here, committees, commissions, and sub-entities. So that's where our task force page is. You go to the bottom, it's in alphabetical order. On the left side says Task Force on Access Through Innovation. So here we'll list upcoming meetings. The roster can be found here, and eventually there'll be, I believe, a form field where you can subscribe to be added to a listserv. So anytime anything goes up for public comment, or there's some kind of survey going on, or there's a meeting, or we have a special speaker coming, people who are following the project will get these updates. Additionally, if
actually, Mimi, sorry to interrupt, but the actual agenda listing page has the drop down where they will subscribe.
That was my next
at the
place.
bottom. Okay.
Yeah. So additionally, if you are on our ABLES page and click on upcoming meetings, this lists all the State Bar meetings. So, for example, today's meeting. That's it. Right there. So this is where you'll find the agenda materials for upcoming meetings. They will be posted here. If you go to the bottom of this meeting page, you can also subscribe. This is where you subscribe. I believe it hasn't been added yet, though. Right now.
Correct.
You put in the
IT is working on
service
it.
request, and it should be done hopefully sometime this week. But at that point, fill in your name and your email, and you'll be added to the subscription. Also, if you're wanting to see any of the archives, first of all, on the left side shows webcasts. So, for example, someone wanted to say, hey, I wanted to follow along with the meeting today. Do you know where I can watch the webcast? You could tell them all the webcasts are listed right here. So you would click on it. It says in progress, agenda, review event, and you could watch it at home. Also, there's a archive as well. So if you happen to miss a meeting and you wanted to catch up on what happened at the meeting, that will be available a week after, roughly a week after the meeting takes place.
Any questions? Terrific. Okay, Randy, you want to talk about the schedule of meetings?
We do have a schedule of meetings, and we've asked that if you have any conflicts on the schedule already, to send an email to Lauren, and Lauren will work with the leadership team to determine if we will have a quorum, anticipated quorum for each of the scheduled meeting dates. These are meeting dates of the entire task force. If needed, the subcommittees may also have meetings in between. If so, those will be added to the schedule as needed, but they would all follow the requirements of Bagley-Keene. They would be separately noticed 10 days in advance with their own agenda, etc. And we could conduct those not necessarily in person. We could do those through video conference. We could do those through teleconference. But the main takeaway for the schedule is if you haven't looked at it yet, please do so as soon as possible. And if you have any concerns about being able to make a meeting date, either in person or from a notice location that you can attend remotely, let Lauren know right away. There's a couple of things related to the schedule that I think Lauren wanted to mention as well.
Okay, and just going back to the schedule, as you might imagine, it was very difficult to arrive at even these dates amongst the leadership team and avoiding, holidays and board meetings and ethics committee meetings. So, but we also understand that all of you are very, busy, engaged people. But to the extent you can, clear the conflicts, we really appreciate it. However, if you can't, please let us know. And it will really only be in the event that we just can't make a quorum or we're missing key people amongst even the subcommittee leadership ranks that we may have to, come up with an alternative. But yeah, I just, for travel, well, I really already touched on that, but after the meeting or at the end of the day, we'll send out an email to everyone with the travel reimbursement form and the instructions again, just to have it handy. And we ask that you try to get that in no later than 30 days after the meeting. And our expenditures are highly scrutinized, so we really have to follow the travel policy to the letter, and receipts for everything that are clearly marked or required. But we're happy to help you navigate that, and once you get it down once, you probably you'll be on board with all of the little nuances. The final thing I wanted to mention is that we would like to gather some biographical sort of blurbs of a few sentences, maybe 2 to 5 sentences for each of you that comes from you. I mean, yes, we have seen your, extensive, bios or resumes and materials, but we would like to have that handy to either share with, there will be some interest in the task force and its members and who they are and what their backgrounds are. So we would like you to share that with us, and I'll send out a message prompting that with some guidelines. But I'm not sure that it would be posted at our webpage. I don't know that we've fully decided how it will be utilized, but we wanted to have it on the ready and something that was vetted by you and prepared by you, not by us guessing what things to mention. That's all.
Lauren, you'll send out an email to everybody
Exactly.
asking for that.
Yes.
Okay.
That'll come soon. Thank you.
Kevin?
Okay, I might be jumping the gun on this, but as I look at the 3 subcommittees, there seems to be a lot of cross-fertilization there in terms of the work they're going to be doing. And you may be addressing this in the next part of the meeting as to attendance of like a member of one subcommittee might want to attend the meeting of another subcommittee and so forth. If you're going to do that in the next one, I'm perfectly happy to wait.
It's a perfect setup. If there are no other questions about the schedule, why don't we go into talking about the subcommittees and how they're going to work, because you are absolutely right. And we've already had conversations this morning about the fact that one person really interested in one thing really wants to talk about the other thing as well. So, Randy, do you want to talk about the subcommittees?
So the charter that was adopted by the board had 3 main segments to it, something on AI and on authorized practice of law, another section on the rules, the ethics opinions, advertising, and then another section on business formats, alternative business structures, and MPP. And we sort of took our lead from those 3 components of the charter to develop essentially a divide and conquer approach. And so we have established 3 subcommittees that can actually operate as independent bodies if we need to meet separately, and each subcommittee will take on a separate piece of the charter. And as Professor Moore was noting, even though these things were enumerated as different things assigned for the task force to study and report on, there are topics within each of those sections that overlap. They are not exclusive at all. And so, for example, if you're talking about the regulation of the unauthorized practice of law or the definition of the practice of law, it's hard to have that conversation without also getting into prohibitions that restrict lawyers in the sharing of legal fees with non-lawyers, or prohibitions against lawyers participating in entities that practice law where there's any sort of non-lawyer ownership or investment or non-lawyer principals, partners. They overlap. We understand that. And the same thing with regard to talking about business structures. It's hard to talk about a multidisciplinary practice or an alternative business structure without knowing whether or not the entire operation itself might be subject to the overarching prohibition against the unauthorized practice of law. And we realized that you basically didn't have a choice as to which subcommittee you were placed on. Leadership had to take a hard look at the credentials we saw, the skill sets we saw in all of your very nice personal statements and applications and bios, and we tried to deploy people as we think will work best. But the structure of the meetings will not prevent the integration of each of these topics for the final report and recommendation. The meeting plan is that while we would start with a meeting of the whole and go into breakout sessions for each subcommittee, which will be concurrent, we will be returning into the plenary session after the breakout sessions so that the leadership of each subcommittee can then report to the full body exactly what were the issues and topics and questions addressed, what consensus was being formed, what lack of consensus might be there, because if we can't reach consensus at the subcommittee level, maybe that's something that can be forged with the full task force. But returning to the plenary session after the breakout sessions is the way for each person. And we had some early meetings this morning with the people who have graciously agreed to become subcommittee chairs. We have meetings with them where they themselves have said, well, they're kind of interested in another topic. They don't want to miss out. And the return to the meeting of the whole in the afternoon sessions will allow each person, regardless of which subcommittee they're on, to engage the discussion, the deliberative process for all of the issues that are before the task force. While there might be consensus positions elevated from a subcommittee to the full task force, the actual recommendations made to the board will be a vote of the entire task force. So no one gets left out. The other thing I wanted to mention about the subcommittee structure is that each subcommittee chair has been given a vice chair who is someone who had a role with the former Rules Revision Commission. And so Mark Tuft, Professor Moore, Judge Chang, each had a very in-depth role participating with the last revision of the rules that became operative November 1st. So no subcommittee will be without a resource in terms of the key regulations that we will be studying ultimately and possibly recommending for change. They will be a presence through all of the subcommittee activities. The last thing I want to say about the subcommittee process is that it could be that one group's work will take a little more time and effort than another's. If so, then in consultation with General Counsel, we created these as subcommittees as opposed to working groups so that they can actually work independently. And if the unauthorized practice artificial intelligence group needed to work between meetings in an actual meeting setting, then we would go ahead and we would notice that and we would hold it. It would have its own agenda, it would have its own posting. And in that regard, Mimi asked me to emphasize that if you are going to attend a meeting, either a subcommittee meeting or the full task force meeting remotely, the requirement is that we need to know your remote location 10 days in advance when the agenda actually gets posted. So please, I know things happen at the last minute. Don't think that the ability to remote participate means that 2 days before the date of the meeting you can say, I can't come, can you please just notice my office, because I'm afraid at that point it's too late. That's correct, right, Brady? We need to have that 10 days for the official notice. And that's all I really want to say about subcommittees, other than the fact that the subcommittees will all be tackling this afternoon some introductory discussion questions. The chairs of each subcommittee have some questions to allow you to get your arms around your part of the charter, to hear each other's initial points of views, ideas, but that there will be some assignments coming out of those subcommittee discussions. And assignments will be given primarily to just 2 people, so we don't run into any problems. But those assignments would need to come back to staff in time for the posting and the actual distribution of agenda materials. And our next meeting is set for January 18th at this point. And so we would be looking for any materials, anything you would like to share or report, part of your report in your subcommittee to come back to us by the 8th or earlier, if possible, in January. Yeah, Brady was kind enough to, in part of his introduction, to identify the fact that although Justice Edmond, Joyce, Toby, Randy, Mimi, and Andrew will be floating around during the concurrent breakout sessions wherever we're needed. If they needed Andrew on an ethics issue, he would be there. If they needed me about the project plan, I would be there. But each subcommittee will have a constant. They will have, for the UPL AI subcommittee, Brady will be there. For the alternative business structures, multidisciplinary practice, Dawn will be there. And for the rules, advertising, ethics opinions, Mia will be there. And we did this with some careful thinking because it could be that the UPL subcommittee wants to talk about an unprecedented California rule or statute defining the practice of law. And if we were to do that, we could create interest on the part of the Federal Trade Commission as engaging in possibly anti-competitive activity. We wouldn't want the subcommittee deliberations about the policy to be derailed or distracted by a potential legal liability issue at the state bar. But Brady will be there. He's from our Office of General Counsel. And when we had issues come up with the Rules Revision Commission, we similarly had a Office of General Counsel liaison. And if we note the legal issues for them, they will take care of it. At an appropriate time, there would be legal advice, if needed, to the state bar, to the board. Similarly, with regard to the subcommittee on the rules and the ethics opinions, Mia Ellis, supervisor from our Office of Enforcement, will be there. And we similarly had a representative from the Office of Enforcement with the Rules Revision Commission. And of course, they're very interested in any changes we're making to these disciplinary rules. These are the rules that they charge in disciplinary proceedings to protect the public. And they need to know exactly how we're changing them, what is our thinking, what's the intent. A lot of these prohibitions have long-standing, important public protection purposes, and she'll be able to take that back to the Office of Enforcement. And if we need more information for her, she's our liaison there. Dawn is with the subcommittee on alternative business structures and multidisciplinary practices. She comes from our Office of Access and Inclusion. And a lot of the previous discussions and studies, if you've read the MDP report from the ABA and all of those other things, there's been a large focus in terms of the business structure on satisfying the access needs of corporate clients. And so how can Disney get the lawyers they want from the UK and from Canada and the United States to work together on something, together with the accountant consultancy groups. And MDP didn't get very far 10 years ago, even though it was touted as being one-stop shopping, because I think there was a lack of focus on the actual need of individual consumers. And so as we look at business structures, we want to focus not just on the interest of big law combining with the accounting firms and satisfying the need of the corporations who want a different delivery method. They don't like the traditional fee structure. They want to go to a different type of fee structure. Dawn will be there because she's with our Office of Access and Inclusion. We want to retain a focus on what Professor Henderson called in his legal landscape report, the people law sector. And so if we're going to propose an alternative business structure or an MDP or something brand new with its own acronym, it should have as a primary focus the people law sector and access to the low and modest means, the indigent, etc. We're not just looking to give a business opportunity for Hamilton Civic Conference. And so those are our 3 subcommittees. We believe that the meeting structure will allow everybody to understand exactly what's going on, and we hope that there's some trust with that process, that you can proceed with talking about unauthorized practicing law without being exactly on top of what the current discussion is on the fee rule. That you can talk about an MDP or APS format without knowing exactly, well, what's going to be the abrogation of the prohibition on UPL? How far is it going to go? We will be coming together at every meeting as a body of the whole and be able to formulate the recommendations as a plenary group.
Joanne.
I have 3 questions, 2 for Randy, 1 for Brady. For Randy, the questions I've heard are we going to have minutes of the subcommittees and the main task force, and are those going to be posted somewhere? And the second one is, are the subcommittees going to be webcast? How are we, if we're going to be breaking out into concurrent groups, how can the public follow any of them in that respect? And then the one for Brady is following up on Kevin's question. What are the Bagley-Keene limitations for a member of this task force that's not on a subcommittee to attend, participate, listen to another subcommittee? There you go.
With regard to the question about minutes, we will be doing what is required by State Bar Policy and Practice, which is to have posted agendas and action summaries. So there will be action summaries of the task force and action summaries of subcommittee activity as well. What was your second?
Webcast.
Okay, so that is constrained by the limitations of our building. And so in both Los Angeles and San Francisco, we have main conference rooms that are enabled for live streaming and webcasting. It's not a functionality that's available in any of our satellite rooms, unfortunately. So what we're planning to do is that when the main group, the plenary body, breaks up into the concurrent subgroups, one of the subcommittees will remain in this room, or in LA, the comparable webcast-enabled room, and will be accessible to the public. And it will rotate as we go through each meeting day. And so for this meeting, the Rules, Ethics, Opinions, Advertising Subcommittee, Tara and Professor Moore's subcommittee will stay here and will be fully accessible through the live stream and archived in the webcast. Next time they won't be. If we're in LA, they'll be in a satellite room, and it might be Andrew's group on MDP and ABS that will get to be webcast. But I'm afraid we're limited by the available rooms that have the technology to be able to provide that access. But I think by switching around, it makes it possible for people to follow. And again, once we go back into the later afternoon meeting of the whole, each subcommittee leader will be reporting out what they discussed. And so if you're watching that latter part of the main task force live stream, you will be hearing exactly what was discussed.
Joanna, would you please repeat your third question? Maybe everybody else's memory is better than mine.
Well, it's Brady. Do you remember what the question was?
I do. It was about whether there's a Bagley-Keene issue if members of one subcommittee go to the meetings of another. And there would not be any issue there because they're not a member of that subcommittee. They wouldn't be subject to Bagley-Keene with respect to that subcommittee. They would need to the extent they participate as a member of the public because, again, they're not formally a member of that subcommittee.
Kevin, did you have all your questions answered with respect to the subcommittees?
I believe so. No, the question I was wondering about, what were the Bagley-Keene limits? And I was not so much concerned about attending a subcommittee meeting during one of these, meetings of the entire task force, but more a meeting that was taking place before one of the main meetings of the entire task force. So if you're not a member of the subcommittee, you don't have to give the notice of where you are. You can call in to listen to the meeting. And if you participate, it would be as a member of the public, which means at the beginning of the meeting, any comment that you might have, you would give. Is that correct?
That's correct. And you truly would be a member of the public because you're not a member of that subcommittee.
So there would be a limit unless a member of the committee wanted to direct a particular question to the task force member who is attending as a member of the public.
Correct.
Okay, thank you.
Other questions, either about the charter or about any of the subcommittees, or how they're going to operate? Randy mentioned that the subcommittees are going to meet at the same time, but then come back together as a whole and report out on what the discussion has been. The only exception to that will be today. Today, we're going to try to devote as much time as possible to each of the subcommittees to try to meet. And so we'll build in as much time as we can and literally have you go till the end. And then the description that he gave of future meetings will kick in. Other discussion?
And the action summaries then are all that is required on behalf of the subcommittees today, then they go to you. So if there was some sort of action summary that came out of, I mean, because you said there's no meeting minutes, it's action summaries, and that goes to you.
That's correct. And so the task force as a whole will have an action summary, and they're different from minutes because they don't, they're not a transcript of everything that was said. They are a reflection of motions made, seconded, and votes taken. And that's what we will be reporting. And I don't think we'll be taking too many votes today for the body of the whole. And even in the subcommittees, we were looking to have introductory discussions and make some assignments. But what I've asked the subcommittee chairs to do, something that I found to be very helpful in my other work with volunteers, is that at the start of each subcommittee breakout session, the subcommittee chair will request a volunteer of the subcommittee members to be the scribe for that meeting, just to take the notes of the discussion. Of course, someone from State Bar staff also will be there, and the constant staff person will be there, and the vice chair from the Rules Revision Commission, who, each of them are good note takers themselves. But we would like one person in the subcommittee to be the scribe for that session. And once you do it, you're off the hook because the subcommittee chair will say, whoever hasn't done it yet, please take the notes for this subcommittee session. Because we want, in addition to just the capturing of the actual action, to have some record of some of the flavor of the discussions that were had, so that when we do come back in the main session, if there was consensus reached or there's lack of consensus, there can be some actual vetting of, well, why were you not able to agree on that change to the fee split rule? Or why did you agree that ABS is better than MVS? And if someone is taking notes on each subcommittee during the subcommittee discussions, then those notes will be a very valuable resource going forward. But those will not be the official record. The official record will be the action summaries. And we'll be developing templates and working with the staff persons for each subcommittee so that those will be recorded and captured and ultimately posted with the agenda for each next meeting.
Other questions or discussion about the charter or the subcommittees? Okay, then why don't we move on to talk about what the ultimate product is going to be. You know, talk about the form of the report and recommendations.
Okay, included in leadership's memorandum was an enclosure providing the final report and recommendation of the California Supreme Court's Advisory Task Force on Multi-Jurisdictional Practice. Now, multi-jurisdictional practice is not a topic we're discussing, but it's very similar to what we're looking at in terms of the type of reform that this body might be recommending. And the same burden of persuasion that was on that group will be on this group, both at the board level, with the Supreme Court, with the legislature as to any statutory changes. And so I really encourage you to take a deep dive into the content and format of this report. And I'm going to walk you through it a little bit, because that is the essence of our deliverable and the format that it will take. And so if you go to the very beginning of the report, at page 5, and you can look at this in, outside of the meeting and study it closer if you want to. But the introduction to the MJP report, which is basically the question of, can lawyers licensed in non-California jurisdictions be allowed to practice in California without taking a bar exam, without having a moral character review, without taking an oath for California? And the answer was yes, to some limited extent. It provided greater access, it changed the law, but also assured continued public protection. And the start of the MJP report was what were the voices for change? What is the reality in terms of interstate cross-border practice? And so our report, our final deliverable, will similarly need to articulate what is the need for change. And you could say, well, you know, we watched with interest what happened to Avo Legal Services when a new owner took over and said, well, half the states hate us, another half love us, but it's not worth the trouble. We are going to cease and desist with offering our fixed fee legal services, even though we think it's serving a segment of consumers of legal services whose needs are unmet. We're going to abandon this because we don't think the regulatory environment is fostering it. That could be one of the statements of the need for change here, but there could be others. But the opening section of our deliverable has to be a description of what is the need for change. If you go to the next part of the report, I'm going to jump ahead, starting on page 14, the Supreme Court's task force made sure that they demonstrated their complete competence and thorough understanding of the existing regulatory landscape. So since the topic of NJP involved unauthorized practice of law, this section of the NJP report surveyed all of the laws governing the unauthorized practice of law. What were the prohibitions? Where are they found? Are they found in statute? Are they found in case law? What are the exceptions? What are the operative definitions? And we too will need to do that same step in developing our final report and recommendation. We have to talk about what is the existing regulatory landscape in which we are considering possible changes, initiatives, reform, etc. And so in this case, we may not only be looking at laws governing lawyers or unauthorized practice of law. We're looking at topics like artificial intelligence. Is there law presently regulating artificial intelligence? Are robots allowed to provide surgical assistance or actually do the surgery itself unregulated? Are driverless cars allowed to be, tooling around downtown San Francisco without regulation? Autonomous drones, are those allowed without regulation? These may not be the same self-learning, high-level AI activities that might be necessary to replicate the type of service that a lawyer provides, but they are technology being used in the public that could harm the public interest that are being looked at and are being regulated. Last year, 2017, Congress introduced its first bill that includes a definition of AI, actually includes two definitions of AI because they weren't sure if they could cover it all with one definition. But we will have to also look at not just the legal landscape of the regulation of lawyers, the legal practice law, but also what else is out there on the topics that we're looking at. Artificial intelligence, alternative business structures, non-lawyer passive investment in a practice of law business. And so a section of our report, our final deliverable, will need to address that landscape as well. And once you get that part of your report done, if you jump ahead to page 20, you're looking at the particular problems. And so it's one thing to say the advertising rules or the fee split rules are inhibiting innovation. And you almost say it as a self-evident statement, but that I don't think would meet the burden of persuasion either before the board or before the court or before the legislature, because I think they need to know what is the specific legal service activity, what kinds of products or services will enter the marketplace if you change this rule. Who will it serve? How will it increase access? And what aspect of the existing law prohibitions are you abrogating in order to make that happen? And so, of course, we have prohibitions against non-lawyers engaged in the practice of law. Like every state, we have statutes that prohibit the unauthorized practice of law. And for good reason, because there are notarios and other persons who might prey upon immigrant communities, other vulnerable people, and essentially commit a fraud on them. If we abrogate the definition of the practice of law to allow for non-lawyer technologists or other online providers to be in that space, we have to carefully make sure that that baby doesn't go out with the bathwater. And it would have to be pointed out in the final report that we were very careful about that. Because again, I think that's part of our burden of persuasion to our audience, to be able to say, we had a very careful consideration of the existing law, what the purpose of those laws were, and how our changes are going to improve access to justice without impairing the longstanding protections that have been in place. If you jump ahead to page 27 of the report, what I've described right now might be a thumbnail for bullet points, but there will be a meatier part of the report, which you see on page 27 of the MJT report, where when you have your specific proposal for reform, you need to identify what was the consensus, and if you go to page 28, the reasons for the change. And so the regulators, whether they're the board, the legislature, or the Supreme Court, it will be important support to be able to say, we reached consensus on A, B, and C for reasons 1, 2, and 3. We don't have consensus on these other points, and we have not made a proposal on those points for these reasons. And so when the Supreme Court Advisory Task Force was looking at out-of-state lawyers practicing in California, there was the option of having something of a waiver procedure. You just petition the court to be waived in to become a full-fledged practitioner. The Supreme Court Advisory Task Force did not recommend that, and for good reasons. They were concerned that that would not afford appropriate levels of public protection. They preferred, for certain activities, that it be a certificate of registration for out-of-state in-house counsel. But for a more limited activity, like taking a deposition for use in another jurisdiction, that was done on a fly-in, fly-out basis. As long as you were within the limited scope of that type of activity, you didn't even have to identify yourself or be certified with the state bar. And so these nuances and details about the nature of the actual initiative and reform that we're proposing really needs to be supported by the understanding of why we agreed that this would work, what were the points in support of it, and what were the points that we felt that were risks, but we felt could be taken safely in this circumstance. The last part of the report, I don't want to take too much time, jumping to page 41, is that in the MJT report, there was recommendations for actions by the judiciary or the legislature, and there was a statement of the individual recommended areas of reform, but there wasn't an actual implementation part, at least not in 2002. That came later in 2004 when the Supreme Court had an implementation committee. And in talking with Leah, we only have till the end of next year to carry out just the policy study and proposals. I don't know if it's going to be this body that would articulate the actual bill text of a statutory change or the red line strikeout of a rule of professional conduct. We may need a more nimble body to be able to carry that out, but we will need the sufficient detail and explanation of the policy of the recommendation and even some language that supports it in order to enable an implementation committee to take it to the next step. That's what I think we're looking at as our deliverable. It is no small task. And if you look at the actual style and tone of the MJT report, we're not doing a law review that is burdened by a bazillion citations to academic reports and studies in jurisdictions. We have a library of resources that we're going to talk about that we're going to make available to you, but the report itself should be as lucid and clear as to what is the problem we're seeking to solve, how does it affect the existing law, how does it continue to preserve public protection, but how this change will improve things for access to justice. And if our report does that, then I think we will have present our recommendations in the best light and have met our burden in terms of articulating something that would be fit for consideration.
Toby, I just want to clarify something. We keep talking about how it's a year to do this, but as I look at the schedule, we really have 6 months till the June meeting to come up with be far enough along to send it out for public comment. And then we take a couple months off and get public comment back before we come back for the last 3 months or so to fine tune it. So that the goal really is much quicker than a year.
And on that score, what we are looking at going out for public comment may not be, again, actual rule text, changes to rules, but really the concepts of what would be handed off to an implementation body. So a recommendation that the regulation of the authorized practice of law, for example, be supported by some articulated definition of what constitutes practice of law. Interestingly, if you read the MJ report, they considered but decided not to go there. If you read the report that the State Bar's multidisciplinary practice group issued, I think it was 2001, the MJP task force of the State Bar actually did have a recommendation, said, define the practice of law. It's overdue. We'll deal with the FTC issues. We'll deal with the over-under inclusive problems. But if you want to reform the unauthorized practice of law, it's almost impossible to do so without a definition. And so those are the types of things that would be a tentative proposal that would go out for public comment in July. And we also have the option of doing surveys. And so we have at our disposal a consulting group that can help us create statistically relevant, scientifically valid surveys in order to support our activities here. We didn't really have to do that with the rules revisions, but here it might be important. Do we know whether consumers are open to AI providing a legal service to them autonomously? Are they okay with going to a website powered by a logarithm to do their simple will or trust or power of attorney? Or would they have a greater trust and confidence if an AI system were monitored by a lawyer? Robots do surgery, but they have to be monitored by a physician. Or are they only comfortable if a group like Technotaries has sophisticated AI at its disposal and helps law firms use them in the traditional delivery model? That would be something very interesting to hear from the actual consumers. Is it different in metropolitan areas from the rural areas? Andrew's community might not potentially be comfortable with autonomous AI algorithms delivering their simple legal document preparation just because of the nature of the difference between the big city and the rural areas. And so having the opportunity to do a survey at the July mark so that we will have coming back after that both public comment on tentative proposals and statistically valid feedback on survey questions will allow us to get into the home stretch of finalizing our report and recommendation. But Toby's absolutely right.
Yeah.
We don't have until December to wrap it up. We have to have a pre-formed vision by July or so that we can refine by December. And Leah has said that if we get it into the board by December, even if they don't take it up till January or early 2020, that still would be okay.
Jean.
Thank you. Randy, I have a question. Are we able to supplement that data of our own surveys with external sources that might already have surveys or data collected?
Yeah, when I said the form of the report doesn't have to be the typical law journal academic report, it wasn't meaning to say that we couldn't use and rely on all the library of studies and data that are out there. It's just that I wouldn't want it to be overburdened by that because I think the focus is on the precise recommendation for change and how we support it. But definitely, any resources that we already have or know of through social media, through other avenues, would all be informative and would improve our report.
Great, thank you.
Kevin?
You mentioned in the surveys, the focus seemed to be on the consumers. I'm wondering if you might also consider, just to keep in the back of our minds, survey of lawyers who might have tried to use this type of technology or may have been sort of warned off it by the current regulatory framework.
Well, we would be looking at surveys that would be open to all respondents, and we'd be working with our consulting group to make sure the questions are neutral and that we have questions that gather all the information that we want to gather. We have 3 subcommittees, and I would imagine each subcommittee at a certain point, the right time, would be contributing what they believe are the right questions to include in the task force survey.
Yes, Laura.
So that's a follow-up question to that idea is we don't have the burden of coming up with the neutral questions that need answered. We can sort of come up with a framework of questions, because I think how questions are asked to consumers is really important in getting the right data.
Right, and that's why we're using a professional consultant to help us do that. We don't want the underlying data we collect to be unreliable and create any sort of questions for the recommendations we're making.
Other questions, comments, thoughts about this final product, where we're headed? And thank you, Toby, for the 6-month reminder.
I have one. I just wanted to kind of reiterate, it might be a good idea to include, when we include the public, to use all different types of mediums, Twitter, LinkedIn, et cetera, to then at that point capture some of those comments, et cetera, of folks who are interested. We could use that survey and get it out that way as well.
I think that's right. We're going to have our media consultant who will have a complete strategy for all of that. And I think the surveys and the tentative proposals that would go out for public comment would be a very key piece of that outreach strategy. And it would be kind of ironic if we were the technology task force and we did not use all of the modern communication methods to get the word out about our tentative recommendations.
Well, and I think that would also be our opportunity where we would help you all craft messages for your social media, so you could direct people to the survey instrument through all of the feeds that you have going. And so we certainly want to take advantage of all of the technological capacity there.
Yeah, I was actually going to add that comment that if we then are supplied with maybe, hey, if you're going to be sharing this, this is the language in order to share it, I think we can definitely all adhere to all the rules that we have to while being innovative.
Great. Other thoughts, comments, discussion? Okay, Randy, are there resources that you want to tell us about?
I'm actually going to let Mimi.
Mimi Lee with our office, Professional Competence, is going to tell you about, we have a Dropbox collection of resources. This topic with the bar started some time ago with a planning session where the bar Board of Trustees looked at an Oregon State Bar Futures Report. And of course, that's not the only report. There are many reports. There are many studies, the MJP studies, the MDP studies. Texas revised their definition of the practice of law, and then they tried to do it again. They had a study. We have collected, and many thanks to Joanna for keeping the pipeline flowing with everything she finds as well. But we have collected quite a library of literature that is at your disposal to read on the various topics. And because of the volume of it, we're not trying to email things to folks, but we have created a shared drive where you can access that. And Mimi can tell you how you can actually find that stuff.
So in the back of the room, there's a piece of paper that has a short URL I've created, so it's kind of easy to remember. And when you go to that link, you'll find a Dropbox folder. There you'll find a bunch of stuff. One being meeting materials we posted there in case you've lost the email where we emailed you the meeting materials. You can find that here in this folder. Resources. So for each subcommittee in this resources folder, we've organized some of the articles, reports, law review, various kinds of documents that we've collected relevant to your subcommittee. And some articles you'll find in 2 or 3 different folders, the same article. Some of them will just be in one folder depending on the substance. But here, you can start some of your research, or if you would like to know what else is out there, we've tried to collect reports from other states, other countries, other bar associations. And so this would be a good place to start in your free time to start doing some research as to what else has been done there and what people's opinions are on. Additionally, travel.
And maybe if you couldn't see that, you've got it broken down into those items that you think will be of particular interest to each subcommittee?
Correct. The folder 1 is AI UPL, folder 2 is lawyer conduct and ethics opinions, folder 3 is ABS and MDP, and then folder 4 is general law and tech type of reports that we found. And then the state task force folder has what other states have done similar or in alignment to what we're trying to accomplish, or so you'll find that all there. Additionally, some administrative stuff like travel resources are there where you can find a copy of the expense report and travel policy, the calendar, and roster. Now, by having the link and clicking on it, will only give you access to view the documents. So it won't give you the access to upload or contribute to or modify the folder. So what I will do after this meeting is send your email an invitation to join this folder. If you're going to have to create a Dropbox account with that email address that's been invited to join the Dropbox folder, and that at that point you'll have access to upload stuff or to modify anything, so that if you and your subcommittee would like to utilize this folder as a central hub to collect your documents, to collaborate on different parts of your report, this is one way you guys can do it.
Quick question, are all of these documents publicly accessible? So is the Dropbox publicly accessible?
It's publicly accessible, like you can view it, but if you want to contribute to it, you'd have to be invited by myself.
So can we comment on documents within the Dropbox?
Let Brady.
That's when you're going to start running into the Bagley-Keene issues. So, and I think that this will be discussed by each subcommittee chair. But the idea is that discrete parts of assignments will go out and either to individuals or pairs, because a group of 2 does not rise to the level of a Bagley-Keene group. And then you would do the work individually or in pairs, send it in centrally, and it could be distributed, and then the discussions would take place at a notice meeting.
So no Dropbox comments.
What we did typically with the Rules Revision Commission is when a drafting team prepared a proposal for a change to rule, is that it was sent to staff, and staff turned it around to the full task force, or the commission as it was back then. And the task force members had a certain deadline before the agenda materials were due, that if they had anything they wanted to respond to, comment, have their own further edits to those changes, that those would come into staff. And then we would collect all of that input, and it would actually become part of the agenda materials. There would be the so-called email compilation. Professor Moore was our great keeper of a lot of those in terms of if Tara or Andrew had something about something that was the team of 2 prepared for the UPL subcommittee, that they could provide that comment to staff, and it would end up in the actual agenda materials. And so everybody would get to see your feedback on whatever they're doing. It just wouldn't be shared among yourselves directly. It would be filtered up to staff and redistributed officially with agenda materials.
I just wanted to add something in response to Heather's question about whether the Dropbox is public, because I think there might be a misunderstanding. I mean, we are sharing it with this body to use as a tool. And I don't know if it was our intention to share that short link and open it up to, the world, or whomever that might be. And maybe it's not been, I realize that's, we've got the link back there on the piece of paper, and, there are ways, I'm sure. Are you okay with them sharing that with someone that might, outside of this body?
Yeah, we are not using this online resource for anything that would be protected or sensitive. And so it is a Dropbox link. If a member of the public submitted a California Public Records request for the link and for every article and report that the task force is studying, we have to produce all of it. And so if the alternative is give them the link and let them look at it themselves, I think that's all right. I would encourage you to just share it because you want to share it. But if there is a particular interested party or stakeholder that wants to be able to follow along and be immersed with this project just as if they were a task force member, then I would welcome them perusing our library. We have lots of good stuff there. It would inform their views as a stakeholder and interested person to read a lot of these materials. And what we would be doing as staff, as Brady was saying, at subcommittee level, there could be assignments going out, is that we would always be looking at the library and we would be teeing up for those two team members all the things that they should look at as they carry out their assignment. And so if we knew that it was the Tennessee report, the Alabama report, and the Oregon report that had something on for-profit matching services, then we would call that out for you as you tackle that assignment. You wouldn't be left at your own devices to just do word searches of everything there.
Other questions, comments, thoughts about anything? Okay, I think that's lunch in the back of the room. So we are going to take our lunch break. We are scheduled to come back together at 12:45. I think lunch is in here, so you just grab a box and have it at your seat. We're scheduled at 12:45 to start some of the presentations. There's going to be a presentation by Ivy Ashton, Professor Henderson, and Professor Moore, and then we're going to break into our subcommittees finally. Anything else for the good of the order before we break for lunch? Okay, thank you.
I don't know, I know this will work for us.
Okay, I think we're going to try to get ready, and next up is Ivy Ashton, so if we could ask you to take your seats. Ivy Ashton, I think, is known to many of us around the table. Randy, you want to take a second to introduce him?
Sure. Ivy Ashton is the founder and president of Legal Server and Houston AI. He has much experience providing technical assistance to nonprofit organizations in regards to the designing, developing, and implementing information knowledge management solutions. He was the co-founder of the Illinois Legal Aid Online, and he developed the first web-based platform to deliver legal training and support to volunteer attorneys and pro se litigants in Illinois. In addition to his work domestically, he has significant international experience assisting governmental and non-governmental organizations in developing information technology solutions that increase efficiencies. And I don't know what you think of when you think of AI, if it's, James Cameron's Terminator or HBO's Westworld or whatever it is, but Ivy's going to tell us what is the reality of artificial intelligence. Ivy.
Do I need to push something here?
Yes.
You did.
There you go.
Awesome. Can you guys hear me? Great. Well, thank you for having me. Again, my name is Ivy Ashton. It's 2 letters, I and a V.
One second. I forgot. You need to call back in.
Oh, okay.
Give me 1 second.
Welcome to Reservationless Plus conferencing. Enter your conference code.
It's not calling. No, the volume's on.
It's not a presentation unless the technology doesn't work.
It's not a technology.
Yeah, that's right. I've now just jinxed my entire slide deck.
Enter your conference code followed by the pound or hash sign.
Yeah, no, I'm trying to call, and so I called it.
You try to.
Wednesday item.
Welcome to Reservationless Plus Plus conferencing. Enter your... Thank you. You are the first participant.
I guess so. Awesome. So again, my name is Ivy. For those who are curious, it stands for Roman numeral 4. A lot of people look at me weird when I say my name is Ivy, but my dad's the third, I'm the fourth, so my parents call me Ivy. I'm an attorney based in Chicago. Thank you again for having me today. I want to have a conversation about how technology is being used to help people that can't afford attorneys. And I just want to start out by saying, 20 years ago when I was starting my career, the internet was just a thing. It just became this thing. And my first job out of law school was doing international human rights work. So I actually worked in Bosnia right after the war. I worked in Kosovo during the war. And then I worked at the World Bank, helping design the legal information infrastructure for the country of Albania. And a lot of the same excitement, a lot of the same buzz back then was just around technology called the internet. We hear a lot of buzz around artificial intelligence, so I want to have a conversation today and see if we can make it tangible and see if we can see how it's really being used and if it's hyped and where it's hyped and whatnot. So when I was preparing my slides, I was thinking of how to put this in context, and I was reminded of an interview that Gene Siskel did with Oprah Winfrey in 1998. And as she tells the story, it was the first time in her career where somebody asked her a question and she was completely speechless. He asked her the question, Oprah, what do you know for sure? And she literally didn't know how to respond. She's like, what do you mean, what do I know for sure? And he said, what in your heart of hearts do you know for sure? And so as I was preparing this, I was thinking about, what do I know for sure? What I know for sure is that our justice system doesn't work unless everybody has equal access to it. It was designed specifically around the concept that it would be open and equal to everyone. I know for sure that the solutions that we're building right now to do that are going to be defined as simple. We're going to make processes simpler. They're going to be smart. They're going to have things that we think of as intelligence. And they're going to be delivered through something called a web service. This is actually a really important point. I'll come back to it in a little bit, but they're going to be delivered through something as a web service. So simplicity, right? This is what our legal system looks like to most people that are lawyers. So our legal system was written by lawyers for lawyers. And if you're not a lawyer, it's really challenging to navigate our legal system. When we think about simplicity, we think about removing the barriers to the things that stand in our way to get into the justice system. So when I think of tools that are being used, oftentimes they're very simple tools that we might see in other parts of our life. We might need to translate from one language to another language. We might need to translate from legalese to plain English. These tools tend to be conversational. So one of the principles I think is really important to understand when we talk about all of this is to talk about the concept of what a system is. And simplicity often happens through systems. So we're going to look at how computers work at their core, and we want to think about computer systems, we want to think about justice systems, and what is a system, how does it serve us, things like that. Intelligence. We're going to talk a lot today around the concept of intelligence and talk about things like conversational interfaces and how those types of things work. And we're going to talk about web services. So I actually want to start here because this might be the most important thing I say. So I'll say it now. There's a concept in technology called web services. And what we ought to stop doing is thinking about websites. Right? So I go around the country and I see lots of people are talking about websites. We're going to build a new website. What if I told you in 10 years the websites are going to be a lot like fax machines? Right? We're probably going to have them, but they're going to serve a different purpose. And I'll just give you kind of a tangible example. So I've been in San Francisco for a couple of days on business. Last night I wanted to go out for dinner. And I wanted to do a quick search to see what kind of Asian food was near me. I typed into my best friend Google, Asian restaurants near me, and I got a menu on the side that showed me restaurants, where to go, there were reviews, it was all structured. I could click on it and go right to it. I literally asked the internet where I should go for dinner, and it gave me back information. How did that work? It worked through web services. One computer calls out to another computer, gets information, and brings it back in a structured way. So a lot of what we're going to talk about happens through web service, and I'll show you some examples of this. So it's an important piece of this. All right, so let's deal with the hype first, right? Because there's a lot of hype around AI. So I want to start out by telling you that we are 18 years into an era in history that would be called, it's a 25-year era, so we've got 7 years left in this era, that history will write about, right? So if you think about things like Enlightenment and the Industrial Revolution and things like that, this is an era in history. Some people call it the 4th Industrial Revolution, some people call it the digital transformation. And it's being defined in the first 18 years by 3 technologies. The technologies are blockchain, augmented reality, and artificial intelligence. It's the most exciting time for anyone interested in technology at the intersection of technology and law. In my opinion, it's the most exciting time to be a lawyer and be involved in technology. The stuff that's being designed today is literally changing the way that we work, the way that we live, and the way that we interact. So it's the 4th Industrial Revolution. Who knew that there were 3 industrial revolutions? I didn't. Like when I started doing this, I was shocked, and everyone kept calling it the 4th, and I was like, I've heard of the Industrial Revolution, but what are the first 3? So it turns out that the first one is when we mechanized things. It was defined by steam engines, and when we started building machines that did things that humans used to do. So huge impact on like textiles, where people, instead of knitting, we built looms to create fabric and things like that. It changed the way that we worked. The second industrial revolution is when we added electricity to things. So if you think about this industrial revolution, if you think about, we used to manually pump water. And then somebody figured out that you can hook electricity to it, and we built pumps to automatically do it. It completely changed how we worked and lived. It's mostly powered by oil and coal. Another thing that was developed during the second industrial revolution was the internal combustible engine. And we got lots of things like mass production and assembly lines. Lots of people moved from agriculture into the cities, and the world shifted. The third era has been around the idea of automating things. This is lots of computers. They kind of define it from like the 1950s to 2000, when we started to automate things. And the current phase we're in, the 4th, is being defined by intelligence and training things to do things. So now we're using, we're trying to get cars to drive us to places without a driver and things like that. So it's being driven by that. I think most people that think about this era of time think about how the mass impact is so much bigger than any other era of history we've lived in when the technology hits. And there's always 3 takeaways. Anytime there's an industrial revolution, there are 3 takeaways. Right? It changes the way that we work, that we live, and that we connect to each other. There are always winners and losers. That even in AI has losers just like it has winners. And oftentimes we create systems that lock in the winners and lock out the losers. So just keep that in mind as we go through this. So I said there was hype. And I'm guilty of this, by the way. I hype AI a lot. But I think it's important to kind of understand the cycle of hype. What happens is we start to see computers doing something, and we assume that because it can beat somebody in chess, or it can beat somebody in the game of Go, or because a car can drive itself, that it can do anything. Right? So then there's usually followed from the hype as a crash, where we just like give up. We thought it was going to completely change the world, and it didn't do anything. And then there's a period of time where we start applying it and kind of reality sets in and we plateau out. That's kind of where we are now, in my opinion. We're starting to plateau out. We're starting to see what the technology will do. We're building applications. It isn't as powerful as people thought it would be, but the way it's powerful is really, really powerful. So what is artificial intelligence? A lot of people think artificial intelligence is this. Does anyone in the room know what this is from? I'm like super old now, my kids don't know what this is. I'm like, yeah, 2001 The Space Odyssey, right? HAL 2000. So this is a form of artificial intelligence. It's called general intelligence. The notion is that I can talk to a computer and the computer can understand the words I'm saying and respond, and that it literally has human level intelligence. Right? That is at best 12 years away. At best. That's the most aggressive prediction, has it 12 years away. There's another prediction that has it 200 years away. So somewhere in that time frame, we might see general intelligence, but we're nowhere close to it. Some people think it's this, right? Remember when IBM Watson beat the winner of Jeopardy in 2011? It's crazy that was in 2011. This is a form of artificial intelligence called question and answering. We're going to come back to this. It's actually a really powerful type of artificial intelligence. This is IBM Watson. And a lot of us think of this, right? How do we automate things? So the way that I define artificial intelligence is the automation of a single discrete task chained together. These are tasks that we used to have humans do, but now we have computers do them. It's a simple definition. And there's lots of definitions of it. That's how I think of it. I think about it at the micro. All we're trying to do is automate a single task. And when we chain them together, that's when it starts looking impressive. So artificial intelligence at its core is just math. It seems like it's lots of other things, but it's literally just math. Who saw the movie Hidden Figures? Right? Awesome movie. If you haven't seen it, it's a great movie. Do you remember what they called the women in that movie? Computers. Right? Because they were really good at one thing. Right? So Katherine Johnson was the hero of that movie, or one of the heroes. Do you know what her superpower was? She's really good at math. Do you know who the antagonist in that movie was, or one of the antagonists? IBM's mainframe computer, right? Because back in the 60s, the computers were called thinking machines because they could calculate things much faster and much more accurately than humans could. And that was the threat in this movie, is that they're going to take all these women that were super geniuses at math and move them out and put a computer in them. You hear this word a lot, algorithm, and I have this huge pet peeve in our space, in our legal and community space, where people get a word and then they say it, and then they start saying it in sentences, and it sounds like it should mean something, and if you don't know what it means, then you feel dumb, and you're like, but you don't want to ask, and so people will say, well, the algorithm will do that. It's an algorithm. What algorithm? What are you talking about? Right? So I always like to bring up words like that because hopefully we can bring them closer to us. An algorithm is a recipe. Right? It's just a sequence of instructions telling the computer exactly what to do. An algorithm is 2 + 2. Okay? An algorithm is 2 cups of flour, 3 cups of sugar, and a stick of butter. Now, I've never used that recipe, but it sounds wonderful. Artificial intelligence is an umbrella term that lots of people use to mean lots of things. One of the things that I've started calling, I've stopped trying to use the word artificial intelligence, and I've started calling the computers prediction machines, because artificial intelligence at its core is prediction. And I want to prove it. I want to play a game with you. All right, so this game is called the Akinator. I need somebody I literally need someone to raise their hand and answer and think of a character. So I found this game like 7 years ago. My kids loved it. And I was fascinated by this game, so I tried to figure out how it works. And it turns out that it's going to prove my point. So the game is this. You can think of a character, I want somebody to think of a character. It could be a real human, it could be a movie character, they could be alive, they could be dead or whatever, but think of a character, right? Pick one.
Batman.
Batman. Awesome. The Akinator has no listening devices, there's no way of knowing any of this, so let's see how long it takes it to figure out what you're saying. Is your character a girl? No.
I can't see it. What does it say?
All right, well, hold on. It probably just needs to. All right, sorry. Let's try it now. Here's your character.
I was gonna say, Batman could be a woman now.
Does your character have human skin?
Yes.
Yes. I don't always know the answers to the character of some of these questions. Is your character a famous YouTuber? I'm going to say no.
Famous YouTuber.
Is your character real?
Yes.
To my kids, that character is real. Is your character a superhero?
Yes.
Is your character from, Japanese anime?
Oh.
Is it related to Marvel? Is it?
Is
it DC? So the answer is no? Maybe?
He's not a Marvel character, no.
But it is related.
I'm gonna disagree. It's not a Marvel character.
That's all right.
It is not. Not at all.
Let's go back. I mean, how can you be a superhero if you don't have superpowers?
Does your character have a Batman logo on his chest?
A Batmobile on
Does
it
your
has to be
character
that.
like it?
I like it.
Wow.
I like it.
All right, so that was a machine using a type of prediction called Bayesian math or Bayesian algorithms. And what it's predicting is it has seen literally millions of examples that all have characteristics. And so every time you give it an answer, it calculates the probability of how close you are to all of the millions of characters that it has seen. And when it hits a certain threshold, as you answer more and more things, certain characters become less likely, other characters become more likely, and it hits a threshold and it gives you the answer.
I like the game.
That's artificial intelligence. It seems like it's human intelligence, but literally all it did was math, right? So we're talking about prediction machines. So let's go back to this concept about systems for a second. So I think it's really important to understand how systems work, because systems actually at their core are really easy to understand. And again, just put whatever word you want in front of the word system, and I think you'll see that all systems work this way. Systems do three things. They receive input, they process, and they give output. So in that last example, the input was, they asked a question, we gave it an answer, we inputted something, they processed it, and then it gave an output. It didn't know enough, so it asked another question. That was the output it gave. We gave it input, it processed it, and it gave us output. That's how computers work. So oftentimes when we talk about artificial intelligence or prediction machines in law, people get really nervous because what they start to say is, what are you telling me, Ivy? Are computers going to take the jobs of lawyers? And I'm like, that's not what I'm telling you, right? Ultimately, what I'm telling you is computers are going to help lawyers, but people get really nervous because they're seeing jobs disappear that used to be done by humans, and now computers are doing them, so they worry that computers are going to take lawyers. But if you break down the anatomy of any task, this is what a system looks like when you put a human involved. Right? So this is actually a good diagram of how artificial intelligence actually works and how it's trained. So you have your input, you have prediction, right? The processing is the prediction part. It might give you an action, which the software did in that example, and it might give you an outcome, right? It might follow that line. But when you put a human in there, the prediction informs a human's judgment, and now you've given a person information, maybe through prediction, to then make a decision, and the human takes the action. Right? So like if you look at what radiologists do in medicine, radiologists see scans of tumors and things like that, and they can look at it, and they're trained, they have lots of experience, and they can detect when there's abnormalities and figure out if it's cancerous or not, things like that. Computers can do that too. But oftentimes, the computer's actually a little bit better than humans now at detecting this. But when you put the computer and the human together, it's even more effective. So it's like 94%, 93%, the human's 93, the computer's 94, but together they're like 98, right? So when you put judgment at the top, that's how a lot of artificial intelligence is working out. The other thing that's important here is that the action that the human takes based on the information it was given, based on the prediction, then becomes training data to train the computer, because now it has another observation. So I don't know if that makes sense. I don't think I explained that very well. Computers learn through AI, learn through training data, through seeing observations. So when a human makes a decision, the computer takes note and says, okay, we put this out and the human decided to do this, and it trains, and that's how it helps it work. Does that make sense? All right. So one form of artificial intelligence that we see more and more of is what we might just call predictive analytics. This is where we're trying to literally predict something. There are litigation banks popping up all over the place that are trying to take data from courts to figure out what the likelihood of an outcome is in a case, and they might fund the case. So if the likelihood is a high dollar verdict, and it's in the right court and has the right judge, there are people that will come in and say, we'll fund this entire litigation. We just want a percentage of the money on the outset. They're using predictive analytics to try to find the needle in the haystack, to find a case that's going to make them lots of money. We use predictive analytics to try to determine the capacity of legal aid agencies. We're trying to figure out how long cases are going to take, how many days they'll be open, what are the likely outcomes based on the data. So we see a lot of this in our work where we're doing predictive analytics around that. There's a company based here in San Francisco called Casetext, great company. If you don't know it, you should follow them. They're really inspiring. They're trying to predict, in the legal research world, case law based on citations in your brief. So if you give them a brief, they'll tell you the citations in the brief, what the other side's likely going to argue, and they're trying to predict like what the other side's basically going to use to argue against you. Very cool. This company isn't around anymore. They just went out of business, but what they were trying to do is really interesting. They're based in Toronto. The site was called this2.co. And what they were doing is they were trying to take the uncertainty out of divorce. So they analyzed 58,000 divorces in Toronto, and they were trying to show, based on information about your case, what your likely result was going to be, how much alimony you were going to pay, and what your attorney's fees were going to pay. And I love the premise of it. Like, the premise, first of all, is that you have to think that divorce is rational, which is not. But if it were rational, and you said at the beginning of a business deal, you're likely going to win $50,000 alimony. You would say, awesome. But I haven't given you the full picture yet. You have to pay $75,000 in legal fees to get that $50,000. You want to do that deal? Like, the rational person would say no. So what they were trying to predict is saying, in a divorce setting, this is likely the amount of money you'll get, and this is likely the fees you're going to have to pay to try to create, to remove that uncertainty in the case. So predictive analytics, the whole notion is to remove the uncertainty. Artificial intelligence is search. Right? So if you've heard me speak before, you've heard me tell this story, I apologize. I need to find another story. This is one of my favorite stories of all time. And I think it proves the point, it proves a couple of points. One of my best friends graduated law school in 1992, and he went to work for a big law firm in Chicago, and he worked for the managing partner of the law firm, who was a world-famous litigator. And he was so excited because he got to go work for this really famous litigator and learn his skills in court. And he said his job every day was to go to court, and he would carry boxes and briefcases, and he would sit and take notes all day in court. And he said, my job started at 3 or 4 o'clock every afternoon. That's when I actually got to work. Because when we came back from court, what the lawyer would say to him was like, all right, Dave, I need you to go do X. And whatever X was, it usually took all night, and then, you got very little sleep. He was always working on all these things. So they came back from court this one day, and there was a stack of depositions that were about 6 feet tall, and he said, Dave, I need you to read through every one of these pieces of paper and find this one word. And I forget what the word was, it doesn't really matter. So they need to find every place that word was ever used in those documents. And then he left, knowing Dave was going to be up all night doing this. So Dave turned to the paralegal and he said, do we have those depositions on floppy disk? And the paralegal said, we did. He said, bring me the floppy disk. So he brought back the big floppy disk and he put it in his computer and he hit Control F. And he found the 19 places that word was used. And then he marked it, wrote it up, and he walked in an hour later to the partner's office. He said, I found the 19 places that word was used, and the lawyer said, there's no way that you read through all of those pages and found that. And even if you have, I've got to believe that you missed something. And Dave said, I don't think so. And the partner said, how? He said, Control F. And so he told him a story about Control F, and the partner was like, oh my God, this is magic. I was super excited, and the worst part of the story is he went back to the other partners in the firm a week later, and he told this wonderful story about Control F. And he said, you just cost us $1,800 because we could have billed for Dave's time looking for those words, and you just solved it with technology. My point in telling that story is because search really is artificial intelligence, but it's also, now we laugh at that story, but this is what artificial intelligence is now. So a lot of artificial intelligence, like if you look, over $1 billion in 2018 has been invested in legal tech. $1 billion, which is more money than was invested in the last 5 years combined in legal tech, right? So a lot of people think that technology is going to disrupt law, right? One of the places that it is disrupting law is through search. And just think about it from e-discovery and things like that, where you have to find certain things. But also think about it being able to search a video for something and just telling it what you want to find. Like that kind of AI is being developed now, or audio. So instead of watching through hours of video, you can just tell it, I'm looking for where this guy was holding a beer in the bar and threw something. And the AI can go through the video and find it. They're working on that kind of stuff. So a lot of artificial intelligence is search. Artificial intelligence is language. All right, I'm going to spend a little bit of time on this. This always happens, I'm probably almost out of time, right? So I'll go through this quickly. First of all, language is the oldest technology we have. You're going to see things about, you're going to hear terms like natural language processing, entity extraction. Entity extraction is where the AI reads through documents and tries to figure out things in documents. So a lot of companies are investing for contract review now, but it can be used for things like looking in eviction notices to pull out the address or to figure out what the reasons for the eviction are. The entity is the address, and it tries to extract it out of the document. There's a concept called natural language generation. You might be surprised to know that if you're a sports fan, if you read a lot of sports online, most sports articles are written by a computer. And the reason they're written by a computer is that the way they're doing it is they take out the information out of the box score of the game, and they've literally seen millions of games be described by journalists, and they just fill in the exciting words that make it a good article. So initially when Golden State beats the Lakers or whatever, basketball game we're talking about, it will write an article around that. That's called natural language generation.
I'll tell you, my kids are in team sports. We use Team Snap, which is an app.
Yeah.
I can download an article about my kids' game right after it's over.
Yeah.
And they'll tell you exactly what you're saying.
Yeah. That's awesome. Just tell me how much. Keep going.
Yeah.
All right.
11 minutes if you're sticking to it.
All right. 11 minutes. All right. So I'm not. If you know me, I'm not very good on brevity, so I apologize. Artificial intelligence to speech. We're going to see all of this in action in a minute. So I just want to call out that a lot of what we're looking at is around speech. So there's lots of AI around speech and trying to get voice, both speech to text and text to speech. There's some translation stuff here. So here's a really interesting way to think about the evolution of technology. And this occurred to me about a year ago, and I've been using it in talks because I actually think it helps kind of frame the conversation that I want to end on, which is every 5 years for the last roughly 25 years, we have changed the way that we interface with technology. And I want to show you what I mean by that. So, so we used to interface with technology by typing commands. It's called command line. A lot of computer programmers still use command line. We used to tell the computer to do certain things by telling it in a language. So we had to learn the language for how to talk to the computer, and we would say, you know, if this, then do this, right? So this is what command line interface looks like. Prior to 1992, this is how we interface with technology. In 1992, and these are like rough, estimates that actually this stuff, some of this stuff came out before then, but the big revolution in the early 90s around computers was the creation of the graphical user interface. So when Steve Jobs and Bill Gates created, the Apple interface and Windows 3.1, we literally could drag a mouse and click on something to open it. So no longer did you have to know how to talk to the computer, you just had to know how to drag and click on something. And that graphical interface changed the way that we interface with it, and it opened up computers to a lot of people that otherwise didn't know how to use them. So it really expanded the use. 1997, the internet completely changed how we use computers, right? So if we think about what the web did, I mentioned at the beginning of the talk that the work we were doing overseas was all based on the internet, and there was a lot of hype around it. It turns out to be a really great tool. In 2007, there's a slide missing. In 2002, we had software as a service was kind of invented, and software programs started running in the internet as opposed to downloading software. So Salesforce was started in 2002. Coincidentally, our company, which is software as a service, was started in 2002. So we started building software inside of the internet, and this had lots of advantages as well. 2007, the mobile interface, the way we interact when the smartphone came out, the way we interact with it is by touching it or by moving it from one direction to the other. Maybe swipe left or whatever that is. I don't know, that is an app, I think we do that. And then but we can move it, position it, whatever. So that completely changed things. 2012, we come back to this concept of a web service that we talked about before. This is a way, it's called an API or application programming interface. It's the way that computers talk to each other. And what this means, and why I said it was so important that we think about this, is that when you build software now, you build it as an API first. Meaning that, like, if I'm Amazon and I want to deliver the product that I want to sell to you, and you put in your address, Amazon pops something back up that corrects your address or it validates your address. Right? They have every incentive to want to make sure that the address you put in is correct. The way they do that is they actually call the U.S. Postal Service and they ask the U.S. Postal Service, is this a real address, can we deliver to it? Why? Because the U.S. Postal Service is really good at addresses. So they have an API that Amazon calls and puts back in the interface. And so APIs are really important. 2017, we started thinking about things around a conversation. My kids interface with their technology by talking to the technology. They ask it questions and expect it to immediately respond in their native language with the correct answer. And when they call me, they say, call Dad, and the phone calls me. They don't know my phone number. So, which is fine. I wish they would call us now. These are, I didn't mean for this to go that way. Let me see it. So here's some takeaways when we understand that this is how software is built now, and this is what I really I kind of want to leave you with like the current state of where we are, and then I want to tell you where I think it's going next. When we think about delivering legal services to people that can't afford lawyers, artificial intelligence, prediction machines, or maybe we should just say technology, is going to increase our efficiency and is going to allow us to do it. However, if we think about building technology as standalone silos, as websites that you have to know where to go to, that don't talk to anything else, we're wasting our money, right? The way that we build software today is what we need to be focused on, and this is a lot of what our company focuses on now, is building software that can interact where the client might be. But they may not be able to find your website. They might need to get you through Facebook, or they may want to call you on a phone. So what I want to do real quickly is I just want to shift and show a couple of examples. If I can, do I have a few minutes in my...
We've got a lot of flexibility
Okay.
because we're like a half an hour ahead in terms of so.
I have stats
I think you
of
just
my
gave him a
kids.
half an hour.
I can, yeah. Actually, you're lucky. I have to catch an airplane, so that won't happen. But so I pulled up a few examples that I want to show here. And I just want to give you a sense of what all of this stuff looks like, right? So let's just pretend this is what it is. It's a web page, and somebody comes to the web page, and we want to start to have a conversation with them, right? So if you think about how web pages are built now, lots of web pages have icons on them. They have FAQs. So FAQs, frequently asked questions, are a proxy for a conversation. This is what people come to our website are often looking for these things. So we're going to give you a shortcut, read through this list of FAQs and see if this answers the question you might have, right? Where we're going with all the technology is let's just have a conversation with them wherever they are, right? So instead of showing them icons or instead of telling them, here's the FAQ, what's your legal problem? What are you coming to our site for, right? What can we do? So what if I said, I am being evicted. So we might come to our site and it's going through an engine where it's a little bit hard to see up here, but what it did was it took examples of, the software took examples of every time anyone has described an eviction, and it's trying to predict how likely that what you just described is an eviction. So if I had put something in it like the person I pay my rent to told me I have to move out, the software analyzes that text and it says based on the tens of thousands or hundreds of thousands of examples we've seen, it does prediction. It says we're 84% confident that you just described an eviction. But this is okay, so what we tell the software is if it hits a certain threshold, start asking them questions around their eviction. All right, so here it's asking me for my street address. I'll put in some address here. That's my home address if anyone wants to send Christmas cards. All right, so it's hard to read up here, but what we told the computer to do is take that address and send it out to the city of Chicago and ask the city of Chicago what it knows about that address. If it had been in New York, it would have sent it to the city of New York. If it was in San Francisco, it might have sent it to the city in San Francisco. What we're doing is saying, we want to know more about this address. Who knows information about this address? And we send it out to somewhere and say, and what we might see back is there are known building conditions in that address, right? So now we've chained together what we start to think as intelligence to say, hey, there are known building conditions at this address, maybe we ought to ask questions around whether or not there are conditions in the apartment, and the reason you're being evicted is because your landlord won't fix the apartment and you won't pay your rent until they do. Right, so that's everything. And then I can put in, I just did a really easy one here, Jake from State Farm. All right, so that's it. It's a simple interaction. It's just collecting some information. It might give some information back. Again, I wasn't trying to do anything wild. So that's a website, right? So if I wanted to have this on my website, I could put it on anyone's website and they could go there. But what if somebody came to Facebook and found an agency or someone, a law firm or someone, and said, the person I pay my rent to sorry to hear about your problem. I think that you just described, landlord tenant. Can you tell me your address so I can test your record? So I can give it my address. Now it wants to know some demographic information. What if I told it, so the reason I put this in on this one is think about how we collect information when we're giving advice. Someone presents to us and they say, I'm a 48-year-old white man that lives in Chicago. That's something that someone might say, right? The way that we collect information in legal aid is we ask you, what is your age, what is your race, where do you live? But from a conversation, we can just start extracting those entities out of the text and start populating data. So that's one of the reasons I put it here. But what if they wanted to text? Sorry to hear about you being evicted and what happened. So what if we can meet him here? But what if the audio is not working? See, I told you it wouldn't be. Here, let me try this.
Ivy, for us blind people in the back, can you talk and say what you're doing? I can't see a thing.
So I'm calling a phone number.
Thank you for contacting Civil Justice. What is your legal problem?
I'm being evicted.
Sorry to hear about your problem. I think this falls under the classification 63, private landlord/tenant. Please provide your address. Address?
700 Southeast Avenue.
City?
Oak Park,
State?
Illinois.
Zip code?
60304.
State address?
Yes.
Zero current or violations on record. Last thing, please provide your first and last name. First name?
Jake.
Last name?
From State Farm.
Thank you for your submission.
So the point in showing you all of that is to show you that when we start to think about building systems to help people, we need to start to think about where we're going to interact with them. Where are we going to meet them? And the way that we can do it in 2018 is through a bunch of different mediums, right? A bunch of different channels. The way that we might meet the younger generation is through some type of messaging app. The way that we might meet someone in my generation might be through a website. Someone may call a phone line and want to talk to an attorney, but before we even talk to them, we want to screen them. We might have the same engine build all of that. So I wanted to go through those simple explanations just to let you know, or just to show you, that the way that this will impact people that can't afford attorneys will be through these channels. We can give information, we can get information, and so they're really good at things like exchange. So just the kind of the last couple of things I want to point out, and then I'll open it up for some questions, is the other two types of artificial intelligence that we see coming on the horizon that will make a big impact is kind of like the example I said when I asked Google where to eat. It understood that I was asking a question about food and cuisine, and it knew my location, so it had proximity to be able to answer my question. Like, what would you recommend I eat if I'm looking for Asian food and I'm in Union Square? And it came back with results because it understood what I was asking. So a lot of this technology now, and we see this all the time with like sites like Google, is when people have legal problems, they show up at Google oftentimes first. And they ask, my landlord put a padlock on my front door, can my landlord do that? And Google may try to answer that question, right? It's pretty exciting, actually, thing to think about if we can get the answers correct. It's pretty scary to think about what those answers might be right now. The other thing that's happening is, and this will completely revolutionize law firms, is IBM is working on a project called the IBM Debater Project. And what it's trying to do is understand legal arguments. So if I argue this side of the case, it tries to argue the other side of the case. Lawyers will probably be trained by arguing against legal debate in the future. I think this is a way to sharpen your skills. Again, I don't think the idea here is that we're going to replace humans with robots, but I do think that we're at a point in history where the reality is that technology is changing how we will practice law, and it's changing how people that have legal problems will get information and find people to help them. It'll probably put a downward pressure on on lawyers to offer unbundled services and to do things at flat fees. The only way they can do that is if they can get really efficient. And tools like we've discussed here today will help them do that. So, I just end by saying that, I've spent the last 20 years of my legal career, on the sole mission of how can we help people that can't afford attorneys. I'm really proud of what we've achieved. I'm really proud of coming into rooms like this and meeting people that are thinking about these problems. But I'm more than all of that, I'm really, really excited about, if we think about this collectively, how do we work together to kind of solve this problem? And I think there's a great opportunity to do that. So the work that you guys have cut out for you, in my opinion, is God's work. This is really important. You've got, not to add pressure, but I've talked to people around the country. A lot of people are looking at California. They're really anxious to see what you recommend and what comes out of this task force. So I appreciate the opportunity just to have a chance to speak. And I'm happy to answer questions if you have questions and whatnot.
So in the description, and I think just to address for the group, when you talk about machine learning and when you talk about artificial intelligence and training computers to make some sort of prediction based on case data or outcomes or how people search for things or whatever those, one of the things that I think that we have struggled with in the sort of legal tech intersection is where those data sets come from and what those data sets represent. If those data sets are, for those of you who don't, I'll just speak generally about an experience that I had at FJTC talking about trying to get sufficient amounts of data to be able to support the kind of training that IB system would require. And those need to be a ton of records. I mean, I don't know if it needs to be millions, but it certainly needs to be more than 5 or 10 or 1,000. and to try to find those data sets, there was a suggestion made that lots of people use Reddit as a way to ask questions, and that other people in the community will respond, other organizations will respond. It's sort of a, I don't know how many of you have dealt with like How-To Wiki or places on the internet where you can ask those kinds of questions. And one of the problems with using that data set, it came out later, was the fact that the primary user of that service is white males of a certain age. And so it became, unfortunately, it was then something where those of us on the receiving end were like, well, maybe that's not the right data set, maybe that's not the best data set, maybe that's not even really a good data set. And my concern, and I think it's a legitimate concern and certainly something that can be solved, but sitting where you sit in terms of developing things, can you talk a little bit about how do we deal with that, and how does that impact, how do you see that as a technologist impacting kind of the results that someone might get? Because I think the temptation is going to be to build something with maybe not thinking through all the implicit bias that might exist in those kinds of data sets. And I would love for Google to hand over their data set, but my guess is they're probably not going to do that.
Yeah.
So I think it's just one of the struggles. So that's my first question.
Well, first of all, we're probably a year away, but when we get big enough, we're going to buy Google. That's in my business plan. I think
so buy stock in Ivy's organization now.
It can't be that expensive. I haven't looked at how much it's worth. So it's a really good question, and the reason that I've stopped kind of using the word artificial intelligence or machine learning and started just using technology is because I think sometimes we overcomplicate the systems that we're actually building. And so what Joyce described and what I showed is, one method for trying to predict what somebody is describing as a problem is to get a bunch of data of people describing problems and label it and then train an algorithm to predict based on the words they're using or whatever. There is a very real thing called bias in data, and we see that, we see it a lot on Facebook actually, where, and advertisers use bias a lot. So in terms of what you're searching on, they'll recommend certain things, and sometimes the bias is really, really negative. So, point number one is we have to always be aware of that, right? And what I say, usually when people ask me this, I say like, when we invented the car, we also invented the car accident. And when we invented the airplane, we invented the airplane crash. And when we invented artificial intelligence, we also invented negative impacts that artificial intelligence can have. So let's go into it eyes wide open. How I would respond directly to your question, though, is the way that we're approaching it is we sit in a unique spot in that literally millions of people that have legal problems come through our software. So we have example data that we can use to start to train. It turns out it's not enough. It's not accurate enough to be able to train even with millions of records. But we're okay with that because if it doesn't understand, it always gives the end user an option to go to the old method, which is, I'm sorry I didn't understand that. Is your legal problem related to housing? And if they say yes, then it may ask other questions, which is a little bit of an awkward way to get to the answer, but that's kind of how we try to solve for it. The other thing is that we shouldn't leave it to the machines to make all the decisions. All we're trying to do is make more efficient gathering information and giving information. There should always be an ability at some point for a human to get involved and hopefully
Would you like to speak to a representative?
Would you like to speak to a representative? So that's why we think on like hotlines, this is especially attractive because even if we only get 80% of their data, we can save the hotline attorney that amount of time in collecting that data and the opportunity to go back and then train it, then say, no, you got it wrong, it wasn't an eviction, it was a bankruptcy.
Can I just want to add something quick to that answer. I think the other thing is using these methods to actually uncover bias is something that is now going to become a lot more available. So being able to ask a computer system, what is the average sentencing of a Hispanic female within this age group, within this geography, and can you compare that to the average white male's sentence for the exact same crime with these facts? And being able to slice through data like a hot knife through butter is going to also allow us to start to pick these out. I think where the bias comes in is the training material, so using the past. The problem with prediction, especially with sentencing, if you use this, you might actually end up perpetrating some of those biases.
Yes, no, that's exactly right.
So that being said, let's not step back and say, no, what we should say is, let's ask these questions, use these systems to see these discrepancies and biases, and then build towards a world where we have less of that bias. So I actually think that the system uncovering these points of bias is a wonderful thing, because as society, the only way that we typically find this out is when we have a high-profile case, and then lawyers and legal aid groups will devote a bunch of resources to it, and then we start to see all these discrepancies. But what if a normal everyday American can walk into a local law firm and start to have these insights, and that lawyer is equipped with this information? That's where I think the promise of natural language processing with machine learning can go.
Yeah.
Thank you.
Great point.
Sorry. Yeah, thank you so much for your presentation. It's very enlightening and I learned so much. I really appreciate it. I look at this also through the lens of people who do not have English as their primary language. So do you have any insights in that regard?
Yes.
I mean, if I was asking the question, I would have asked it in Spanish. So, and what if someone has an accent?
Yes.
Because when my mother calls me, it doesn't transcribe, her message doesn't transcribe because she's speaking to me in English, she's speaking to me with an accent.
Right. So machine translation is the tool that I think you're describing when you talk about language. So there are tools, in fact, I have a slide that I show sometimes. And what I'll say just up front is the technology is not all the way there yet, but there is a company that sells a pair of earphones for $149 that if you put the earphone in and I put the earphone in, you could speak to me in Spanish and I would hear you in English. And I would speak to you in English and you would hear me in Spanish. Now, in watching the demo of it is awesome. And it solves problems, in the future, like going, let's say I go to Paris for vacation or something and they don't speak English. Something like that might be really useful. In the situation where you're uncovering legal rights, the language translation software isn't anywhere near close to being able to translate at the level of legalese yet. They made a switch in how they train the techniques they used about 2 years ago, and translation software has gotten, like, by an order of magnitude better, like way better. And Google translates amazing. I find it amazing because I don't speak a second language very well. I try to speak Spanish, but I'm horrible at it. But they even have it now with your phone where if you look at a menu in Spanish, you'll read it in English by using your camera to translate the words and whatever. So that's a long way of saying that if you think about it as a tool, machine translation as a tool, the problem that Google is trying to solve for, the tool they built is more like a chainsaw, but the tool that lawyers need would be more like a scalpel, right? They both cut, but it may not be an appropriate tool to deliver information to somebody who needs legal advice or whatever, because it may not translate properly. That said, Google also has it so that if I'm on a web page and I'm in Puerto Rico and I'm looking at something in Spanish, it will detect where I am and it will ask me if I want it to translate it to English for me, and you have no control over that. So there are a lot of legal aid agencies are struggling with it. It's like, oh, Google Translate's not good enough, we can't translate our legal content using it yet. So no, you can't, but you could use it as, you could use it as a starting point, and then you could correct it. That would be more efficient than trying to do it from scratch. And B, it doesn't matter, because your clients are coming to your website, and if Google asks them if they want to translate it, you have no control over that. So, like, get it translated through maybe machine learning, put it on your site so that you have something that they don't have to have translated. So I don't know if I answered your question, but that's a whole discipline in AI, is machine translation.
And I'm going to add something else for the group, just because this is my world as well. Right now what they're working on, and I'm mentoring a group, is all the translations that were done for courts where the client, or there was multiple languages that needed to be actually transcribed. They're using that as the official kind of training material for these systems and trying to figure out those connections. So we actually have multiple decades of various official legal documents, birth certificates, records of employment, et cetera, that had to be translated using some of those legalese terms between jurisdictions. And those are going to be what forms the basis of these trainings for the future.
Cool. That's really awesome.
Yeah.
So I have another question. One of the things that came out of the landscape report, the report that was done by the California Bar that was served as the catalyst for this group, the creation of this task force, talked about the distinction between technology as it gets applied to corporate law and then what they call people law. So that's and in here looking at what you have, I can see lots of applications for corporate law, but not so much on the people side. And I'm guessing, even what we've seen here, you're envisioning, at least
The system has detected that a minimum number of lines are connected to this conference. Do you want to continue your meeting? Press 1 to confirm. If there is...
So you're kind of, the way you described it, you were envisioning it as a front end for a legal aid or a law firm, or for eventually for the lawyer to step into the picture. And I'm not opposed to that, I don't have a problem with that, I just was curious, given what you've shared with us, if you have any vision where there isn't going to be a lawyer, there isn't going to be, there's an opportunity for somebody to walk through and use some of these systems sort of in the people law side, perhaps without or with a very minimal intervention of counsel.
Yeah. So the way that I would answer that question is, the vision is that we want to provide tools to do people law, but that the way that our legal system works, that may not be sufficient. And I'll give you a real world example of something that I experienced, where I went to the internet to do something and I realized that there's a limit to the technology. And I'll just give you the brief story, which is, in 2012, I started having symptoms of something that concerned me to the point where I went to WebMD and Googled it. And I confirmed that what I was worried about is something that I had, so I of course called a doctor and I had to have surgery and go through radiation and things like this. Google was great at telling me enough information to know that I had to go see a doctor, but I couldn't not have solved that problem without a doctor. Like, I wasn't going to make an incision and, I wasn't going to go open up an IKEA, like just cut here and then pull this out and, whatever, right? So my point in saying that is that the same is true with law. And so the way that we approach these systems is that you have to think of it on a spectrum. And at some point, a lawyer is necessary. So things like this, we've actually been working on a tool that tries to analyze things like, what is the severity of the consequence? If I present that I'm being evicted and, I get some information about the eviction, well, I'm a lawyer. I can maybe talk to my landlord and fight the eviction, right? Like, I might have the skill set to do that. If I present that I'm being evicted and I'm a mother of 3 and I have subsidized housing, maybe I need a lawyer because not because I can't handle it, but because if I get evicted, I lose my subsidy, which is a huge problem for somebody that needs a subsidy to live in an apartment. And it means that we're about to put a mother and 3 children on the street. Like, in that case, I would say we need a lawyer, right? So part of what I see happening in this space is building tools that can supplement or make lawyers more efficient, or in some cases just provide enough information that lets me fills out a form, lets me file something, do that kind of stuff, for sure. But there's also a point where I think we need to hand it over to a lawyer.
I'd like to weigh in on that. I always tell my kids, need is a strong word. And as we heard earlier, most people, technically, they could use a lawyer, yes. But they show up and they represent themselves. Obviously, they go to our legal system without lawyers. And one of the things we're trying to solve is, if they can't afford a lawyer, if they can't get the help they need, how can we help them
Yes.
through legal innovation? So I don't want us to be boxing where you're always gonna need a lawyer.
No, I agree with that. And if I sounded like I didn't agree with that, I was just suggesting that unless we completely change our legal system, that there are certain circumstances where you need a lawyer. Like, here's an example I always give. Like, if I get a speeding ticket, I feel comfortable going in and arguing on my behalf. If I was getting divorced and had the threat of losing my children, even if I was a divorce lawyer, I would hire another lawyer. Because I need somebody to stay objective and not emotional about my case.
Right, but most people can't afford one. So what solutions can we provide to make their life easier? Like, allow them to talk to the technology, and the technology, here's the information, fills out the forms they need for them, and spits them out.
Yes.
Something along those
Yeah, no, I totally agree. We should do that. And we are doing that. I mean, lots of groups are doing that. So if I sound like I don't agree with that, I've said it the wrong way.
Thank you very much. I think we can spend the rest of the
Yes.
afternoon.
I have to catch up to that, so. Thank you.
I understand you have Professor Henderson on the line.
Yeah, you can.
Bill, can you hear us?
While we're making technology work for us, I want to just tell you that Professor Henderson, William Henderson, is the editor of Legal Evolution. It's an online publication that focuses on the changing legal industry. He's a professor of law at Indiana University Maurer School of Law, where he holds the Stephen F. Burns Chair on the Legal Profession. Prolific author, lecturer on the legal market. He wrote the report that was, as Joyce said, was the catalyst for creating this task force, and we're very glad that he's able to be with us today virtually to just give us some oral insights on the very thorough report he wrote on the legal market landscape. So thank you very much, Professor Henderson, for joining us.
I don't know if you can see me or hear us. Can you hear us?
Looks like the cameras are connected.
What? I don't know if he can hear us.
Yeah, he doesn't look like he's here.
He does not look like he's here.
He looks very relaxed for.
You may not even be able to see this.
Right.
He doesn't see the message. He responded once and then
Does he see you?
he just write on a piece of paper.
I don't think he
think
sees
so.
her either because she's been waving and he's not been responding.
Yeah. Well, I can see myself.
Should be able to see.
I sent him an email.
So you sent him an email?
Oh, actually, let me just send him an email.
You have his regular phone number for me? Oh, okay. Maybe send it.
Thank you.
The legal. Yeah. You said something now. We can see him. You can hear us or see problems can be solved by a lawyer, if they don't know, a lawyer can help, maybe they have problem. Maybe they have a problem. That's a good start. Microsoft. And then build on Microsoft.
I'll be here for a lawyer.
Yeah, technology that is triage. and say, okay, well, digital
This is what she gave him, and we're on 2241029. So I,
And also, you can do that with better message than if you're doing contract if someone's walking through an online program, they can tell you about it. So I like that we have contracts or maybe there's fraud, like somebody comes out and says, oh, I don't know, break it down. You agree with how much money are you? Right. What did you lose?
I copied it off the email that she had sent him.
Think about it. But, prompted, they would easily come up with. I don't even
She doesn't have his phone number either.
Talking about high technology.
Well, you get to see all the latest and greatest, and then you get to see implementation, so it's vision versus implementation. 5 That's why you always have to have that. Or would you like me to?
That's right. It's that bottom line.
That's right, there's always has to be an opt-out.
Too many corporate voicemail attendants don't give you that.
Have you tried just hitting 0?
Yeah, some of them don't.
Yeah, then I just hang up and stop using that service, because that's ridiculous.
I've got an app that
I don't know, I think it looks like you're looking at something.
some of them. Everybody's different.
That's crazy. But there, I do think you always have to have, I mean, sometimes you can have that option to, it's not just a person, maybe it's just to, like here.
Okay, he said he got it.
You know, we're not getting any reviews. I mean, that's too much. I do think there's a lot of
Oh, yay! Hello, hi Bill. I'm sorry about that, when we sent you the phone number last night, it was the incorrect conference code.
No problem at all.
Okay, are you gonna, well, it's up to you whether you wanna display the PowerPoint or if you wanna just talk, everyone in the room can see you here.
Okay, I was gonna, well, do I have the attention of the task force members?
Yes.
Oh, terrific. Well, it's a real privilege to connect with you folks, and your position to make a really big impact, not only in the state of California, but I think other jurisdictions in Washington, what you're doing, and you got the conditions set forward for success, and so I'd like to help in any way I can. I would like to go through, I think my contribution is primarily technical, and I would like to go through some of the highlights of the report, if that's okay.
Sure.
Please.
Sure.
Okay, so I'm gonna see if if this is gonna let me for me to share my PowerPoint. I'm gonna try. There we go. Share my screen. Okay. Share screen. Okay. 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 All right. Let's see here. All right.
There you go.
Sort of.
All right. All right. So I'm going to go through a high level coverage of my report in hopefully non-technical language, with a little bit more emphasis on the access to justice issue here. So which I think is incredibly important. So I want to just start by just setting the stage here for what the actual market for legal services looks like. From the U.S. Census Bureau, we can break down the market into basically $260 billion market. It's roughly 1/3 serving individuals and $220 billion serving businesses and organizations. And you can see that it's about $70 billion has to be spread around 322 million people. There's about 6 million businesses, of which Fortune 500 really big companies take up a very large share of that. So kind of we think about two markets. Let's think about the individual market, and let's think about the corporate law market or the business law market, because they really operate on two different dynamics. Okay, so let's just talk about the people law one for just a second here, which is the $70 billion market. It's roughly current. If we compare the data, every 5 years, the U.S. Census Bureau conducts a thing called the Economic Survey, which is a snapshot of U.S. business activity. And it has a question there for all kinds of businesses, but including legal services, called class of customer. Who are you selling to? Is your customers individuals, or is it businesses, or is it government? And you can see for legal services, so these are businesses that are in the business of selling legal services. So this is overwhelmingly law firms with a sprinkling of legal aid organizations in here. And you can see that in 2007, 29% of total receipts were generated from selling legal services to people. And you can see that there is a diminution 5 years later in 2012. We won't get the 2017 data for a couple more years, but you can see a significant drop off in the amount of receipts coming from the people law segment. And this is actually, it's not only a proportionate drop off, but actually it was about an $8 billion drop off. And so this is dollars that were going to were generated from ordinary citizens, ordinary people, or individuals, and as opposed to businesses. And you can see a drop off of $8 billion, and with an increase in the business portion. So if we talk about the vitality of the legal services market, well, it's disproportionately businesses that are driving those higher receipts. But if we just segment it on the people law segment, we see a dramatically different picture. This comes from a company called Clio. They provide practice management software, cloud-based, and they've had a huge foothold in the solo and small firm portion of the bar here. And so, and they every year they aggregate data that comes from their cloud-based service, and this is from their 2017 Legal Trends report. Covers 1 million matters, 10 million hours billed, and $2.5 billion in total receipts. And you can see that if you just did, now this is looking at the world from the point of view of a practitioner. The hourly rate is $260 an hour, which sounds like a lot of money, and it is. But in a typical 8-hour day, the typical lawyer using Clio software has 2.3 hours of actually legal work they're doing. They're only billing for 1.9 hours of it, and they're only collecting on 1.6 hours of it, which brings their income to $422 a day. That has to pay for all the expenses of running an office: rent, insurance, health insurance, retirement, and that's really only slightly more than $100,000 gross receipts for a solo or small firm lawyer, which is really painting a picture that there's a lot of latency, there's a lot of underutilization, and actually when you break this data down here, lawyers are spending almost as much time looking for work as they are actually doing legal work, and these are for solo and small firms that can afford practice management software. Some people choose to do it on Excel, but Clio is probably at least representative of your typical solo or small firm practice. Another window on the functioning of the people law market, specifically in courts, is this is a report done by the National Conference for State Courts. This is an organization formed by Warren Burger in the 1970s, and this is really the research arm of the state courts. And they took a picture of the civil litigation in state courts from 10 jurisdictions. I know San Jose County was included in that one, but Harris County, which is Houston, Cook County, Dane County, where Miami is, and several other urban jurisdictions, and it was almost 1 million cases that resolved into a final judgment. What they found out was the median judgment was $2,400, the 50th percentile. The average judgment was $5,400, which means that there's a few really big cases that grab the headlines that are skewing it north of the median, and that 75% of all cases had at least one self-represented litigant. So if you look at it from civil litigation from the state court perspective, and this is data that's hard to get, but this study was done by the National Conference of State Courts and was well funded. You see overwhelmingly that these cases aren't of an economic value that makes it feasible to engage the services of a lawyer. And so what do you see? You see 3 out of every 4 cases doesn't have a lawyer at all here. And this is really a significant a meltdown to what we're observing. The quote that one of the quotes I pulled from the report was, "The picture of civil litigation that emerges from the landscape data set confirms a long-standing criticism that the civil justice system takes too long and costs too much." And I want to just highlight one issue here that the task force should be aware of, is there's only so much we can do. We can do a lot, but there's only so much we can do by the regulation of the bar. A part of really the access to justice is thinking about different ways to resolve disputes through the court system. And I know the Supreme Court is part of this initiative, but that's a huge portion of it, is how do we resolve disputes. This is not purely lawyer regulation that can solve this problem. We're going to think about how we solve disputes here, because this adversarial system where each side lawyers up here is not economically feasible for a large number of these smaller stakes cases. And so this has given rise to what I call the DIY, the do-it-yourself legal economy. And here's just a picture of some of the services that are offered by LegalZoom. LegalZoom is actually headquartered in Southern California, and they're probably the most successful non-lawyer brand that exists in legal services today. But you can see that they're doing a whole lot more than just wills, and they're starting to climb the value chain here. There's a lot of non-lawyer investment in the legal services one. LegalZoom has been successful. The vast majority of them have a much more difficult time getting traction. See an economically valuable problem to solve, but lawyer regulation issues really make it more difficult for them to get traction. But LegalZoom, because they're focused purely on the people law segment and small businesses, and they've been at it for almost 20 years, they've gotten some traction. So I want to just show you one slide on organizational clients. The two, people law and organizational clients, are tied together by a common problem of productivity, but the problems manifest themselves in different ways. For people, it's the cost of legal services. For organizational clients, it's massive amounts of complexity that inevitably create cost strains, cost problems. And so, to give you an example of that, one way. So this is a picture of going back to 1997, which is the first year that the Census Bureau started a classification system that's carried forward for the last 20 years, the North American Industrial Classification System. We start from that baseline. You can see from that snapshot the growth of in-house lawyers going much, much faster than law firms, which is the bottom line, and government lawyers, which is the center line here. The reason this is occurring, and this is a difference of 35,000 lawyers in 1997 working for corporations to over 105,000 working for corporations by 2017. The reason this is happening is that corporations have realized that it's much more cost effective for them to hire the associate that's working for the law firm as opposed to pay that associate working for the law firm and support the higher profits of the firm. And so it's just a simple labor arbitrage maneuver here, which is not sophisticated and not long-term sustainable, but you can see there's a pressure that's building for even the richest corporations basically taking this step to bring their lawyers in-house as opposed to having an outsourced service. It's a non-core function. Legal is a non-core function of the vast majority of businesses, and yet we see insourcing, which is suggesting that something significant is going on in the market. So the common theme, according to my report, that ties these two together is what I call the problem of lagging legal productivity. And here, if you think about anything, if you think about automobiles, I used to give the example when I was giving talks to law firms of I've had 3 family cars in the last 17 years. I bought a car in 1997, which is a Dodge Caravan. I bought a VW Passat in 2003 for my spouse, and then we got a Honda Accord in 2014. All 3 of those cars cost the exact same amount, $23,000, but the quality was getting better. And you think about computers or smartphones. There's a lot of areas where you see these enormous leaps in productivity, which increases quality and decreases cost. Actually, legal services is in a class of is very human intensive, where actually it becomes more expensive over time here. And so anything that's very human intensive that doesn't have these great leaps forward in productivity is going to consume disproportionately larger amounts of our economic output. And the paradigmatic examples of this are medicine and higher education, or education generally. They become proportionally more expensive as well. And so I want to give you just a picture of that. Just think about legal services put up with the meds and ed sector. So this is the consumer price index, and you can see that's the black line at the bottom, and things become more expensive over time, and that's why we get pay raises. But you can see legal services actually increasing in real terms faster than the CPI-U, and you can see college tuition going up even more, and you can see medical care going up even more. Now, what this does is that we need medical care, and so we apportion for it, and we just pay more of our income to get it because it's so crucial. For those of you that have college kids like me here, we also pay more for college tuition. I'm a law professor, and I think I probably benefited economically from these trends as well. But legal services is going up as well. Now, this basically raises the question of whether we're going to have price elasticity issues, which is basically, are we going to substitute, or are we just going to pay the higher freight? And so the consumer price index is based upon this basket of goods. And there's a very elaborate sampling that's done by the U.S. Bureau of Labor Statistics that captures how much what we put in a typical basket that takes to support our households. And these percentages are periodically updated because over time we begin to substitute, buy more of some things because we have the income, buy less of other things because they go up in price or they've fallen out of fashion. And I want to show you in the next slide what's going on with legal services because it's pretty dramatic. The gray bar shows overall CPU. The green bar shows cost of legal services, but the orange line shows basically a diminution in the amount of our income that's allocated to legal services. We're basically taking legal services out of our basket, and we're buying less legal services. Now, this is troubling because it's as if we're kind of shrugging our shoulders and say, well, this money that we're spending on legal services doesn't do us very much good anyway, so might as well just forego legal services and learn to live without it. And that's very, very troubling because it's suggesting that each dollar we spend on legal services is we're getting less of a return for it. That's not what you're going to see with, according to my report, the government data shows that we're spending more on higher ed, we're spending more on medical services, but we're spending proportionally less on legal services. And I think this is because the lawyer regulation rules really limit the ability of productivity gains by collaboration with allied professionals. And so this is at the end of the report, but it just gives you a sense of how much economic, pent-up economic activity there is trying to get into the legal services market, because there's enormous inefficiencies and ability to use technology to have enormous leaps forward to drive down just like my automobile, to drive up the quality and to drive down the cost. And all of these companies have figured out a way to get around the existing regulatory structures, but it would move, I believe, a lot faster if the rules were liberalized to facilitate more co-venturing between lawyers that have the customer relationship and the actual client. And so this looks like a large number of companies, but none of these companies are going to hit home runs like Google or Facebook, these are small niche markets. They're solving a significant problem, but very few of them are getting significant traction here. So the key points to kind of wrap up this is in terms of the breakdown of the people law sector, I want you to think about it from three perspectives. One of them is the clients, because the cost is going up fast. The cost of legal services is going up. It appears that consumers are foregoing legal services, and it's leading to this DIY sector that's not connected to the bar. This has been a boon for LegalZoom, that's for sure. Lawyers are struggling to make a living, so it's not like the existing structure is benefiting lawyers. This is actually hurting lawyers that are serving people, and they're struggling to make a living. And and you see this in law school applications, where fewer people are getting hired to work in law firms because they're struggling to make a go of it economically. And then the courts, where 75% of the cases involve at least one pro se litigant. Pro se means it's self-represented. And I just think that there's a real mismatch between cost of the litigation, the amount in controversy. Other jurisdictions up in Canada and in the UK, and actually a few places in Texas, they're experimenting with online dispute resolution. That's a very promising methodology, could handle a significant amount of lower stakes matters here, but that's beyond the scope of the report. I guarantee we'll see that in the next 10 years. And the last thing is the solution, I think, requires collaboration with other disciplines. My report got a lot of highlights because it was talking about potentially liberalizing what's called Rule 5.4, which limits the ability of lawyers to share ownership with non-lawyers in businesses that are engaged in the practice of law. Not part of that is access to capital, but a lot of it has to do with just getting allied professionals to work together with lawyers on an equal playing field, because this is not a legal problem we're talking about. This is a technological problem. This is a problem of process. This is a problem of design, and so we need legal expertise, but we need the best in class of these other disciplines: data, process, technology, design thinkers to come here and to create a new generation of products and services that can drive up quality and drive down costs. But it's fundamentally a design issue here, and so and I think that the explosion in legal tech shows how much talent is waiting on the bench that would be helped if some of the rules were changed here to facilitate this co-venturing. So that is all I have. I hope I didn't go on too long.
Do we have that ability to ask questions?
Yeah.
Thank you very much, Professor. Let me just open it up for any questions from the group. Lori.
I think my question is, the state fees in buy-in for legal services, do we have the data on where that's coming from? Is this across all consumers, or is this typically purchases that are made in big law services? There's a ton of statistics out there on, who's buying legal, and it's a really small portion of the world.
So was the question? I may not have heard I don't think I heard the question properly. Can Lauren or me or somebody just repeat the question?
Is your mic on?
Is that possible?
It is. Can you hear me now?
Yeah, try one more time. I'm sorry. I'm listening closely.
My question was, so this decline in the purchase of legal services, is the data around that showing that that is purchases made in the big law sector? This is not typically individual consumer purchases, is that right? Or do we have that?
Yeah, you hit that nail right on the head here. That when I showed you that basket of goods and I showed you the orange line that is trailing downward, that is for the people law sector here, because the CPIU is really individual purchases, and so it allows us a window on just the people legal services market. Large corporations almost certainly are spending as much or more of their income on legal services. But you're right, that was purely a picture of the individual household legal services market.
Other questions?
Did I answer your question?
Yes.
Okay.
I think the other piece of that question is, do we know what portion of the individual household market that is there more spending at the high end of the individual market as opposed to the moderate income and lower end? Is that going down faster?
We don't have access to that information, but I can tell you this, is that the budget for each individual in the country is about $220, which is less than one hour of a lawyer's time. Like if you get divorced in the state of California, God forbid, and it's contested, that'll probably cost you approaching 6 figures to get divorced if there's assets to fight over. And so a famous lawyer, David Boies, has said, we have a system where rich people have great access and poor people have very little access. And so, I've hired a lawyer in the last 5 years and I've spent thousands of dollars and got great service. But I'm a person with means, I guess. So we don't have a way to parse that, but I would not be optimistic that it's evenly distributed.
Yes, Alan.
Hi there. I know in Australia and in the UK, they've gone through regulatory changes there to try and address similar issues. And I'm wondering, do you know of any studies that have evaluated the impact that they've had on similar issues, or are there similar issues that prompted their regulatory changes that you're aware of?
What drove those regulatory changes was two things. One of them was a belief that the legal services market wasn't adequately serving the needs of society and individuals, and that was point number one. They wanted to look at it purely from a consumer welfare point of view. And secondly, they had the benefit of having their system federalized, and so it was possible to change the law at the federal level and have that carry forward throughout the jurisdiction. Because of the United States' long-standing history of federalism, the United States would never be in a position to federalize the bar here. And so for those of us that study the market here, we're looking for evidence of what our future might be. If I look at Australia and looking at the UK, I would a couple things that I would say about that is we haven't seen the sky fall in the UK or Australia because of these changes here. We haven't seen any evidence of increase in ethics issues, anything like that here. But in terms of driving greater results for consumers, it's still, I would say, in the fairly early stages of that. And so, I'm looking at it to see what it might. I think it's increased the pace of innovation in the UK, I would say. But in terms of measuring how it's redounded to individuals, it's still too early to tell. You know.
Thank you.
Hi, Bill, it's Heather Morse. Quick question for you. Do we know, in the people law, the type of services that they're purchasing? Are we looking at it as, is it, criminal? Is it the real estate attorneys, family law? Is there any breakdown of that?
Yeah, actually, I can get you that breakdown. There's a the Census Bureau breaks it down by type of practice. And I have an article that has the most recent data in it that I'm happy to make available to the task force. Businesses is the biggest category, about $80 billion. But I think labor employment, from my memory, is about 15 million, 18 million. I think criminals somewhere in the 15 to 20 million, or billion. But that data is actually broken down, and I'm happy to dig it out for you.
Yes.
Hi, Professor. My name is Andy Kuchera, and my question is, I understand the chart about the decline in spending on legal services, and is there a difference that we can tell between what part of that is consumers that are spending less on legal services than they were before, as opposed to maybe the size of the market that isn't spending anything on legal services at all? And can we see if maybe that market has been increasing and that accounts for some of the lower spending?
All right, so let me see if I can restate the question to see if I got it right here. Are you suggesting that maybe because some of the innovations that are taking place, like LegalZoom and the DIY market, that although we're spending less on legal services, we're actually getting more value for it because there's more lower cost options available. Is that right?
Well, that's a possibility, but also is the opposite, where maybe less of the spending comes from a greater number of consumers that are now not spending anything on legal services because they just can't afford any solution at all that's out there, including LegalZoom.
See, I think that latter hypothesis is more likely to be correct, and I say that because 75% of litigants are self-represented, according to the landscape report, which is suggesting that a lot of people are summoned to court or are finding ways to file their own complaint and going to court and feel that they can't afford a lawyer or a lawyer wouldn't do them much good, and they're going it alone. And so I can say that at least in Illinois, where I've been able to get good data, you actually see a diminution in the state population going up and fewer civil complaints that are actually getting filed. And so you see fewer complaints getting filed. That may be problematic unless they have other good options. But you see at least 50% of the cases that are litigated have at least one self-represented litigant. And if they ask a state court judge, they think that's a disaster. That's not good. And so I think that there's really good evidence that people just can't afford a few hours of a lawyer's time here, and they're going it alone. It would be a really fruitful study to do some courthouse studies in some of the bigger counties in California to quantify that problem and to personalize it, to understand what the life problems are that people are trying to resolve, and we don't have the best data on this. Am I being responsive to your question?
That was, thank you.
Okay. If there are no further questions.
One question.
Yes.
Hi, Professor. This is Greg Fortescue. I'm a liaison from the California Supreme Court. I just have a question about your slide regarding the number of hours attorneys are billing and getting paid on. And I think it's between 2007 and 2012. Do we know if the number of contingency fee matters increased over that period of time, and is that factored into that data as well?
I don't know if that's factored into that one. Clio would be able to break it out, though. And if I remember correctly from reading the report, contingency wasn't a really big portion of the fees here. There's so many different types of practice that are not amenable to contingency fees. That's part of the sample, but it's not a big part of it. I'm pretty confident that I read something about contingency fees and how they're handled by Clio. It's a good question to know whether contingency fees are going up or down or staying the same. The honest answer is I don't have it. I don't know the answer to it. My understanding of this data set, though, because it handles criminal law, it handles traffic, it handles wills and estates, it handles a host of things that aren't necessarily amenable to contingency fee practice, but there is personal injury in here, so it's part of it, but it's just not a huge part of it.
Okay, thank you.
Okay, Professor, thank you so much for your time. We really appreciate it. I'm sorry?
Anything I can do to help the task force, please don't hesitate to call on me.
We know where to find you. Thank you so much.
Okay, thank you.
Thank you.
Okay, bye-bye. Good luck.
Thank you. Kevin.
Sorry, I was just gonna say, current trend report. This one. And some of that might have been. There you go.
Okay, thank you, Mimi. I'm very happy to be here. I'm grateful for being able to participate in this task force. But I have to tell you, I am a little bit intimidated as I look around the room. Just to give you an idea, when Ivy earlier asked if anybody had seen the movie Hidden Figures, I was afraid to admit that I hadn't seen the movie, but I had read the book. But back in high school, my last year of high school, we were visited by a Jesuit priest who was a professor at Fordham University Law School. This was in the late 60s. It was the time of Marshall McLuhan, Media is the Message. And he looked around the room, and he seemed to be looking right at me, and he said, "You are a POB." And I looked at him and I said, "What's a POB?" He said, "A print-oriented bastard." And I looked back and I said, "What do you mean?" He says, "You're not into media." And I realize now it's true, because when I use the web and I come across a web page and there's a video, I usually close the tab. I can read 10 times faster than I can look at something and see it. I can, or listen to something. I just read very quickly. So I'm not ashamed of being a print-oriented bastard, but I'm really fascinated by Ivy's presentation and Professor Henderson's presentation. I just find them fascinating about the possibilities. My task today, I suppose, is in a way to put a damper on all of the great expectations that folks might have. But I hope it's not a permanent damper. It's just going to discuss some of the rules that are in play right now. The rules, the title of the slide talks about, is it for public protection, barrier to justice, is it both? And I suppose you could say it's both. I think of the rules as providing 5 protections. And we talk about public protection as being the primary objective goal of the State Bar. I think it's more the protection of the client. In other words, the public being the consuming public of legal services. That's the primary objective of the State Bar. There are other protections in play, protective of the justice system, lawyers as officers of the court, officers of the judicial system. There's the protection of the legal profession in the sense that you want to protect the reputation of the legal profession. There's also the protection of the public, meaning the more general public, not just the consumers of legal services. And then finally, perhaps what might be the bane of the rules and what some people will talk about, the protection of lawyers, that some of the rules are protectionist in the sense that they protect a monopoly that the lawyers might have on the practice of law. Well, let's talk a little bit first about what are some of the core duties of the legal profession. Loyalty, we all understand that. Without loyalty that the lawyer owes to the client, we're not going to have the trust of the clients, the trust that in turn the lawyers need in order for the clients to open up and disclose what their problem is. I mean, clients don't come to us when everything is fine and dandy. They come to us with problems. And sometimes they're embarrassing problems that they caused. It may have been inadvertent causation by them, but still they have caused them, and they're embarrassed. And they don't want to necessarily tell us everything, but our duty of confidentiality is an assurance that will get them to disclose that information to us. Loyalty, trust, confidentiality, feel free to disclose. We're going to keep our mouths shut. Independent professional judgment. There shouldn't be any outside influences on the lawyer's decisions. There shouldn't be anyone saying, wait a second, we can't afford this. Yes, sometimes you have to take that into consideration, but there shouldn't be someone else sitting on your shoulder telling you you can't afford it. On the other hand, it's often used in the same phrase with the word competent. It's the competent exercise of independent professional judgment. There's also the concept of diligence, not neglecting client matters, and zealous advocacy within the bounds of the law. What does zealous advocacy mean? Does that mean you have to be a zealot? No. But it means that you have to go to the mat for your client once you've determined that your client has a good case. Finally, what holds all of this together is the duty of communication. If competence, independent judgment are the wheels of legal service, then communication is the linchpin. You take away communication and the wheels are just going to fall off the vehicle. Let's look at while the rules line up with these. Loyalty, probably the best statement of that will be Rule 1.7, which talks about conflicts involving current clients. Confidentiality, California is pretty unique. We are the only jurisdiction in the country where our duty of confidentiality resides in a statute. Any changes you want to make to confidentiality, you want to carve out a section to the lawyer's duty of confidentiality, unless the legislature is with you on it, it's not going to happen. Courts cannot carve out, not even the Supreme Court, cannot carve out an exception to our duty of confidentiality. Independent professional judgment, that's going to be found in Rules 2.1 and 5.4. 5.4, which has been mentioned several times in the discussions that we've already had. It's kind of viewed as, I suppose, might be viewed as Satan's child. We're going to talk about this in a few minutes in relation to the Avo situation. Competence, Rule 1.1. Diligence, we now finally, after many decades, California has a standalone rule on diligence addressing the issues of neglect and zealous representation. That's Rule 1.3. And communication, very important rule. has been expanded greatly as a rule, a black letter rule, but the duties always existed. They always existed in the common law anyway. So some of the focuses we're going to have were 1.7, 606AE, 2154, and 1.1 we're going to be discussing. Other relevant rules, the advertising rules, 7.1, 7.2. The trust accounting rule, that's come up in relation to some of the proposed changes. 1.16, which is the rule by which a lawyer withdraws and a lawyer is obligated to return any unearned fees. We'll look at Rule 1.2b. This is New California Rule 1.2b, which deals with limiting the scope of representation. And finally, the conflicts rules. In addition to 1.7, we have rules 1.8 and 1.9. Okay, let's talk. There's a few themes. I don't know if I'm going to get to all of them because we do have to move on. I want to make this quick. AVO Legal Services. I don't know how familiar folks are with what AVO was providing to the public, but the idea was there were limited scope legal services for the most part. AVO was pretty much acting as an intermediary, was matching the public, those people who are interested in obtaining legal services, legal advice, with lawyers who might be able to provide them with those legal services and advice. AVO delimited the type of legal services available. Now, AVO is no longer in business. It was mentioned earlier that they were taken over by international brands, and international brands ceased the operation of this particular service. I've gotten my facts from reading all of the ethics opinions that were issued by state bar ethics committees dealing with AVO. And some of those committees actually contacted AVO, asked them questions to clarify precisely what AVO was doing. Subject area. AVO delimited certain subject areas. If somebody logged on to their to their website, you know, do you have a problem, business law, family law, bankruptcy, landlord, tenant, criminal. They also delimited certain packages, legal packages. It could be just advice, it could be a 15-minute, you're just going to talk about your problem, giving you advice. It might be review of document, not document review, maybe what big law would be talking about, millions of pages of documents, but somebody has a contract or a lease that they want you to review and give them some insight into what all those terms mean. Or you could get, they had a soup to nuts package, start to finish is what they refer to it as. And that came in at about $3,000, but they had some packages that were as low as, I think, $50, a lot that were around, you know, $150, a couple hundred, few $100. They had a list of participating lawyers. But before you actually picked a lawyer or chose a lawyer, you paid a fee to AVO, and AVO would hold on to that fee. You would contact the lawyer. And then the first of the month, following the month in which the lawyer may have communicated with the client, AVO would pay the lawyer the entire fee, and then the lawyer was obligated under the contract with AVO to return what was called a marketing fee to cover the costs, the expenses, plus I presume, a reasonable profit that AVO got for making this match between lawyer and client. The lawyer would then pay AVO the marketing fee. It was not a straight percentage, but the fee varied depending on what the package was. So it seems that the fee could increase, but that didn't mean that the percentage would increase, but the total amount of the fee might increase depending upon the complexity of the problem with which the lawyer was presented. But it wasn't a straight percentage type increase or money or total amount of the package times a flat rate percentage. All right, what were some of the issues that were raised in these ethics opinions. And I'm referring to the California counterpart. As it was mentioned early on, California has recently enacted, and they became effective, new rules of professional conduct a little over a month ago. And we have followed, generally speaking, the ABA numbering system and the ABA format and style of writing rules, but our rules still maintain themselves as primarily disciplinary in nature, although they do provide guidance to the profession. And they do regulate. The whole idea in California is we regulate the conduct of lawyers through discipline. So any of these laws, violation of which the lawyer can be subject to discipline, and that's pretty much how we regulate the legal profession. 5.4a talks about a lawyer shall not share legal fees either directly or indirectly with a non-lawyer. This is a big ticket item with a lot of people. Well, sometimes shouldn't we be able to share fees with a non-lawyer? Why is this there? Well, California has about 5 exceptions, not many of which, if any, actually apply in this situation. There's also Rule 7.2, which deals with the fact that a lawyer can't compensate or give anything of value to a person for recommending the lawyer. And there was a big deal. I think that the New York opinion on this particular issue spent a couple, 3 pages explaining why there was a recommendation by AVO of the lawyer's services, notwithstanding the fact that it was a list and not a particular lawyer was recommended, but still the New York opinion concluded that it was a recommendation. Except that you can pay the reasonable costs of advertisements. The question is, was AVO's fees, were they reasonable? Did they reasonably reflect the cost of marketing? And secondly, you can pay the usual charges of a legal services plan or a qualified lawyer referral service. And the lawyer referral services here in California are strictly regulated under the Business and Professions Code. Again, just to step back, so everyone in the room, there are a lot of folks who are not California lawyers. California has essentially 2 major sources of lawyer regulation. There's the rules of professional conduct, just like every other jurisdiction in the country, but there's also the State Bar Act, which is in the Business and Professions Code. And that's not to mention the other statutory codes, probate code, criminal code, which all have provisions that regulate lawyer conduct directly. So, again, understanding that we have 6155 and 6156 of the State Bar Act, it might be necessary that those provisions will require amendment, and that would involve the cooperation of the legislature. I'm not pointing this out as a bad thing, I'm just pointing it out as a fact of life here in California. Second, this was an interesting one that several of the opinions raised. Not all of them addressed it. Most of them flagged it. They said, we don't want to express an opinion on this right now, but California Rule 1.15, the lawyer has to deposit advance fees. Well, there's an advance fee, for example, in the case of AVO, that was paid to AVO. And you could say, well, these haven't been yet received by the lawyer, so they don't have to go in the client trust account. But the question is, it says shall be deposited, shall be deposited. Can lawyers, if you can cut it out in this respect, if you can do it with respect to AVO, can you somehow work out another third party to act as your intermediary to avoid the duty to deposit advance fees in your trust account? Those are things that we're going to have to look at. I'm not raising these issues as lawyer protectionist. I'm raising them as protection for the client. Where do their fees go? Now, I'm not trying to impugn Avo's reputation at all, but I'm just saying if you do have a small company that's a startup that isn't sufficiently capitalized, then there might be a concern that the lawyer might have. Then there's the return of unearned fees. A lawyer is obligated upon the termination. And here in California, client can terminate the lawyer for a good reason, no reason at all, or for a bad reason. Client's given free rein to terminate the lawyer, discharge the lawyer from representing them. And then the lawyer would be obligated to return any unearned fees. Well, who has the fees then? If this is done in the middle of a discussion with the client, what are going to be the lawyer's obligations? These are just some things to discuss whether which will have to be addressed. We don't know. Who determines the scope of the representation? In California, we have a case called Nichols against Keller. And I don't want to tread where I shouldn't be treading, but what the heck. I'll go ahead and do this. It's a California bar exam. What's the use of the California bar exam? To me, the California bar exam, it was for that one instant in time. And I mean, it was an instant in time. By the next morning, I pretty much had forgotten most of what I had learned for taking that bar exam. But you remember and you understand what are the possibilities for clients that are out there. What are the different causes of actions? What are the different claims that can be asserted? Well, we have an obligation. It's a common law obligation that if a client comes in with a particular legal problem in our specialization, we can't ignore any other legal issue that the client has. If the client has another legal issue that maybe we don't handle, we want to limit the scope of representation only to our specialty, we still are obligated to disclose and explain to the client what their other options are. That's what lawyers are obligated to do here in California. And a concern that might arise if you have these delimited categories of legal possibilities, where will you have somebody who is going to step in and apply their knowledge and exercise their Nichols against Keller duties? I'm just raising these issues. I don't think anything I'm saying right now is necessarily insurmountable, but they may not be things that every jurisdiction has thought of in their opinions that they have addressed. But we may limit the scope so long as the limitation of the scope is reasonable. Everybody limits the scope of the representation. If I'm retained as an expert, a consulting expert, or a testifying expert, I limit the scope of what I'm going to represent the client on, or what I'm going to testify. Is going to be in the area of professional responsibility and risk management. I'm not going to talk about corporate law. I'm not going to talk about trial practice. I'm going to limit myself to a particular area. A lot of lawyers will do that. It's an important thing in every lawyer's engagement agreement. But you still have the Nichols against Keller obligation. 5.4C is the independent professional judgment. And 5.4C is the provision that we're going to be looking at. And it's going to come down, anyone who's looking at alternative business structures, where you want a non-lawyer to have an ownership interest in an organization that is providing legal services, then this is one of the provisions that you need to look at and look at very carefully. Satisfaction guaranteed. There's an issue as to 5.4C. We're saying this is satisfaction guaranteed. Well, you tell me how to practice law. Are you interfering with my professional judgment by telling me I have to meet your standards as opposed to my own competence standards under the rules? Well, who's going to define what is satisfaction guaranteed? Is it the client, or is it the satisfaction of a reasonable person who has retained a lawyer? Finally, we have the issue of confidentiality. Well, in the Avo case, the client might complain to Avo. Well, the client is probably going to disclose confidential information that the client has disclosed to the lawyer. Does that lose confidentiality? Does that lose the privilege under those circumstances? These are issues to take into consideration. Finally, duty of competence, that's raised in a number of the opinions. And given the constrained time limits that AGO would have in the, for how long you were going to meet with the client and how much time you could devote to the client's matter, could you be able to perform competently? Who would make the decision as to whether you might need more time? Are you then creating a kind of a bait and switch operation by saying, okay, I'm here 15 minutes, 15 minutes isn't going to be enough time, you're going to need 2 hours. What's going to happen under those circumstances? The artificial intelligence, this is done with virtually no knowledge of what's involved. I feel like I've learned quite a bit this afternoon with Ivy, so you can probably ignore everything I'm going to say right now. But again, competence. The American Bar Association has a comment 8 that a lawyer must keep up with the law. Sorry, not must, but should keep up with the law, which it seems most jurisdictions and most people who write about it view the word should to mean must. But a lawyer should keep abreast of the law, including matters involving the advantages and disadvantages of technology. That's an issue of competence that lawyers have. So if lawyers are going to use artificial intelligence, and I'm fascinated about the possibilities of how it can improve. It's not just artificial intelligence that can be used, say, where a lawyer might not be involved, but also to supplement the lawyer's ability to more efficiently provide legal services. How much must the lawyer know about those legal services? The concept of communication, I think that the lawyer, in order to be able to use this, I think the lawyer is probably going to need the client's consent, or there's going to have to be some disclosure, there's going to have to be some communication to the client about what the lawyer is using. There's going to be the issues of confidentiality. Now, I'm going to raise one last issue, or 2 last issues here, and then I'll stop the program. I'm going to raise an issue that's a little bit radical at the end. But Rule 5.3. In California, Rule 5.3 is titled Supervision or Responsibilities Regarding Non-Lawyer Assistants. That's the people assistants. TANTS at the end. In the ABA in 2012, the ABA changed the word to assistants. TANCE. So the question is, if we're limited to assistants, does that mean just real people type assistants? Or should the rule be expanded to also include assistants, CE at the end, in order that we can assure lawyers that their use of these technologies requires that they apply reasonable supervision and have reasonable knowledge and understand what the advantages and consequences of using that is. Which is going to bring me to my last point, which I mentioned this to a couple of people from the Rules Division Commission, and they gave me a jaundiced eye, which I'm used to receiving. But the question is, we have this new rule, 8.4.1, which talks about representing a client. Lawyers shall not unlawfully harass or unlawfully discriminate or unlawfully retaliate against persons. I'll leave you with this thought, and that is, and this just comes, and again, you can disabuse me, all you tech people, you can disabuse me of this. I know that, as Andrew mentioned before, talked about bias in looking at data. But I just saw a recent report that Amazon was using an interview program, an artificial intelligence program, interview that they discontinued because of it had bias in it. It was discriminatory. against women apparently in the way it was being used. Would this be a violation of 8.4.1 if a lawyer were to use product that was subsequently shown to have ingrained bias in its application? So I'll leave that with you. Those are the types of things that we have. I can't say that I'm resistant to changing these rules, which people made this thing, 2 years. Well, Mark and I and Randy, we were involved in it for 17 years. There were previous attempts at changing the rules. So the change in the rules began back in 2001, and that's when we got involved. We spent a long time, but we welcome. I found this meeting. I've still resisted. I haven't drunk. Okay.
You're sipping the Kool-Aid.
I know. I'm sniffing. No, I'm not sipping. I'm sniffing the Kool-Aid. But I think it's pretty exciting, the possibilities that have been raised. But we're still talking in generalities. I think when we get down to the specifics, it'll become a little bit more realistic for us, and we'll be able to respond a little bit better at that point. Thank you.
Lori.
I think I'm always going to be the questions girl. I have 3. First, can we get a copy of all of these relevant rules in Dropbox so we don't have to hunt them down?
Just so you know, the little blue books?
That's where they are.
Yes.
Perfect. So my other 2 questions are, does California have any rules related to unbundled legal services? And has California adopted a rule about tech competence? Because now there is an ABA rule that says lawyers have a duty to become tech competent in order to,
Okay, I'm going to answer your second question first.
Okay.
Okay, first, the ABA doesn't have a rule. The ABA has a comment, okay, which is not supposed to be a rule, and it just says should, which is aspirational in my book. I'm a words person. So it says should. Unless the Supreme Court tells me I should do something, then I'll take it as a must, okay? But generally speaking, should is aspirational. It isn't required, but it said you should keep abreast of developments in the law, including the advantages and disadvantages of using technology. That was added in 2012. It's comment A to Model Rule 1.1. California did not adopt that comment. Now, as to the second question, if we were in one of my classes, I would just turn around and say, well, what do you think? But instead, I'm going to do something better. I'm going to defer to Toby, and Toby can tell you about unbundling.
There's really 2 places to look. In Rule 1.2.1, 1.2b, 1.2.2b specifically authorizes the lawyer and client to agree to limit the scope of the representation. In the rules of court, there's a whole series of rules that address how you can do that. It makes it clear that ghostwriting is permissible. You don't have to disclose ghostwriting unless you're going to get paid a fee by the court for the work you did. It has forms and procedures for withdrawing from a case without going through the whole withdrawal procedure if you signed up in advance to do a limited scope. So you're going to represent this client only on issues of custody and visitation, and you're not going to deal with dividing up the knives and spoons. Once the custody and visitation is done, you can withdraw without having to go through the whole motion procedure. So yeah, California has been very friendly to unbundled. In fact, wrote a report a number of years ago. The Access Commission developed a report on that it ought to be done and how to do it, and a risk management package on how to do it effectively, which when the insurance companies looked at it, the malpractice insurance company said, we think this is really great and we hate it, because they were afraid it was going to set a standard of care. But
We got to all your questions, right?
Yes.
Wendy?
Thank you. I wanted to add one thing. On the tech competence, it's not a rule, but the California Ethics Technology Opinions do adopt that concept.
So the technology, can you clarify that? I'm a little confused.
There are some ethics opinions that are in the California, written by COPAC, that deal with technology issues. There's a VLO opinion, there's an e-discovery opinion,
Okay.
and they do talk about that concept.
So
And
it
they
has been
adopt
adopted.
It's
under
not
those-
adopted, but it's
Discussed.
It's advisory. It's an advisory opinion only.
Mark.
Advisory opinions only.
Mark?
The rules are not is this on?
Yep.
The rules are not the entire sum and substance of the law governing lawyers, and so you have civil procedures in e-discovery, you've got court rules, you've got case law. In the area of professional liability, there's no question that a lawyer would have to have a certain degree of knowledge and proficiency in any technology the lawyer uses as a matter of loss prevention, so there's no getting around that. I do, Kevin, with your permission, since I have the mic, ask to add one caveat to your wonderful presentation. But I think it's a very positive comment because I know there's a lot of concern about Rule 5.4. One thing about California, although we've adopted the model rules in terms of the structure and the numbering system in large part, we do depart from them in some very important respects, particularly when we get a signal from the Supreme Court. And I'm mindful as we approach this project of the very forward thinking, in my opinion, that the Supreme Court gave us as rule drafters in the Fry versus Tenderloin Clinic case, which is now ends up as a new exception in 5.4, subpart 5, so that you can share court-awarded fees with an organization that is really not a law firm. Tenderloin Legal Clinic is not a law firm, made up of lawyers and non-lawyers. But in that instance, the Supreme Court, in a very important case, balanced the interest and came out with a decision some years ago that in that type of setting, that having the clinic accept a portion of those fees was fine. And so we picked that up as an exception to our rule. That gives us, in my view, the license to examine these issues freely, with the idea in mind of achieving wherever the end result's going to be, which is public protection and also the affordability of legal services to those who need the most. So I don't think we're hamstrung by 5.4 at all. I don't think you have to cash in the entire rule to get to where you want to go. I also would recommend that there are a few other rules that we did not adopt that are worth looking at. I'm thinking of 5.7 in particular. We never got a chance to look at it. 5.7 deals with law-related services. The AD has that rule. Not every state picks it up. It's kind of a complicated rule, but it lends itself to at least a discussion of whether there can be relationships between lawyers and non-lawyers with certain protections that allows a cooperative delivery of services to those in need. So I'm very enthusiastic about the fact that we have elasticity within the existing rules. We don't have to completely turn the world upside down. We may change them, but I think we have room to maneuver in this area.
I just want to add, we are in pretty historic times. Just today, North Carolina became the second state to mandate, as part of their CLE program, technical training on technology for their lawyers, and that followed suit, obviously, from Florida. Big shout out to Florida, with their rule stated 3 hours every 3 years. So you have that ABA kind of suggestion, and it's been adopted by Florida and North Carolina. And I think we're seeing more of that turn to, hey, what does that technical competence look like? And if it's not part of CLEs, how can we kind of enforce that?
So on Mark's positive note, we're going to break into our subcommittees. You're not getting as much time as I had hoped that you would get this afternoon, but at least you'll get the conversation started. We've got some work that we want folks to do between now and the next meeting, so it's important that we at least get the subcommittee conversations started. We probably won't get back here together as a whole again before you leave, and so let me just say, it has been an eye-opener of a day. It really has been lovely to meet you all, and I look forward to working with all of you. Thank you.
If you're on the UPLAI committee, you'll be right next door. And if you are on the MDPABS committee, you'll be at the far room at the end of the hall.
And Rule stays here.
Are we gonna call taxis? Lauren? Are we gonna call taxis to the airport? Are we gonna try to do taxis to the airport?
I don't know yet.
I'm not sure. We should just have our chair. Actually, she doesn't matter.
Cameras are mobile.
We share.
Yeah, either one here.
Is anybody going to SFO? Want to share a taxi? Okay. I'll go by myself.
Oh, okay.
We're going to Oakland at the end of the meeting.
Are we leaving our name tags in a particular area?
Yes, well, you know, you probably should take it so that you can talk to each other.
Okay.
Yeah.
Oh, and you too. I thought we were doing it, but you too. Oh, I saw that.
And where did it say where?
I think you're staying.
I'm not leaving until later, otherwise I would.
Knock over.
Sure.
Coffee.
I'm an email.
Yeah, or is it you? Wait, fine, sorry.
Great
Randy, is
Randy, is it the, yes, I'll see you tonight. Yeah, that'd be great.
and then where's the previous?
Okay, so it is.
Thank you.
And I think maybe more focused towards the front of the room, together.
I don't think I'll see alternative services is very
We changed, we're gonna go to the
Yes, I
Expo,
am.
and I had that my mom. You would have found that these rooms are.
Yes.
Definitely.
For sure.
I had, so I did not know.
We're just saying. Do we move all of them?
Well, I think you're like.
I'm coming. I'm in your group. I'm coming over.
So travel safely. Thank you so much. That's terrific. Thanks.
Just around the shoehorns.
Yeah, just in that vicinity, so we're gonna continue the webcast for this.
Yes.
See right there. We also wrapped tonight.
Yes, it's your subcommittee.
Okay, subcommittee bathroom break,
You're in
water
control.
break, happy break.
Ideally, I'd rather at least have a conversation rather than just. You know what I mean? Like, I just don't know that.
Yeah.
But if there's just. As I'm sure you do. I'm sure. I mean, it's just not good for anyone. So anyway, I just thought I would. Reach out and-
Well, I will definitely bring it up to Neil.
Okay, great.
And see what he has to say. He's of course trying to find the sea legs.
Can imagine.
He was, on the chief staff for years, but this is his first foray into
Yes.
the state prosecutor, so.
It's quite
And
a
Karen was doing
time.
a lot of that work. so.
Yes, I know, and she was great, and all, I mean, it was a humongous undertaking.
Yeah.
I know, but we're supposed to record the technical.
There clearly still a lot of thinking going on.
There's a, yes,
Yeah.
it's here, I mean, and not just here, I know it's.
Yeah, right. It is it's terms of declining scores, it's a national, certainly
Yes.
national trend.
Yes.
But it's, I know it's acutely felt here.
Okay, you want me to take
So
Randy's
I
seat?
was
Is
just
that
wondering, like, some of my best.
Tara's sitting there. You can sit here.
You're just,
Okay.
you know,
Yeah.
it's fortunate when you know it's like, it's
Tara's
not.
sitting there.
I mean, it's not, anyway, just bluntly,
Yeah, I
it's
took a
happened.
bar exam too.
You know.
And it was
Didn't we all?
3 days.
3 days, I know, me too. I'm like telling my students, like, you're lucky.
Yeah.
All
No, but I
right.
appreciate you.
No problem. It's nice to meet you, and
Yeah.
I'm looking forward to this task force regardless. I just thought
Yeah.
I'd throw that
All
out
right,
there
okay.
before you start
All right, good-
hearing all
good to
kinds of
know.
buzz.
Thank you, Rick.
Thank you.
Yeah, good to see you. This one here? Yeah. Already know your name. Good to share. I'm here as well.
You too.
You too. Oh, thanks. Forgot about that.
Now you're official, you're no longer me.
So, Tara Bird's our leader. She's requested a 5-minute restroom break, so that's why we're on pause until she returns.
Bird. I am a probate litigator down in San Diego, and I've been working with the CLA, and so that's why I am here. I know we introduced ourselves earlier, but I'd like to do so again, just briefly, so that we can better orient ourselves to the group. And also, at the same time, I'd like to hear what you're passionate about with respect to either the task force or specifically this subcommittee, so that we can all just get a sense of where each other's strengths lie. Especially for any tech people, I want to hear specifically, what company you're working with and what experience you bring to the table, so that we can direct our questions to the right people as they come up. So with that, Lori, would you like to start?
Lori Gonzalez, I'm with the Raina Corporation, which provides really boring admin work for lawyers.
Can you say that, the name of the
Sure.
corporation?
It's the Raina Corporation. And I am interested in both this task force and access to justice with technology. As someone who worked in the legal field in a support role, I was a part of many cases where the work was very overwhelming and work-life balance was very non-existent, not just for the lawyers, but the people within those firms as well. And on top of that, heavily involved with a lot of access to justice initiatives in my home state. So pro bono clinics, I've administered them, I've run them. I've been a part of helping create state-approved pro se forms. And we keep kind of running into the same problems where everything we do feels like a little step forward in quicksand and no real dent in the problems. And I think a lot of that has to do with how we approach technology and how we approach the idea of protecting clients from themselves instead of sometimes empowering clients with things that I think they can find on Google anyway. So I'm really passionate about how we can both help lawyers and consumers with technology find some answers to these problems that don't seem to be going away.
Great. And what's your home state?
Tennessee.
And you're there now?
Yes.
Okay.
Yes.
And sorry, I forgot to ask, can someone please take notes? If you do it today, you'll never have to do it again. Thank you, Alan. And I'll try to do so as well, so we can confer one-on-one afterwards. Okay.
Oh, sure. Mia Ellis. I'm with the State Bar of California, Office of Chief Trial Counsel in Los Angeles. I'm the department that disciplines and prosecutes attorneys. So the enforcement side, I am your staff liaison for the subcommittee. So any assistance I can provide, just let me know. I don't have a tech background, I'll be honest, but I'm happy to assist in any way I can.
And is there something, can you better identify for us what exactly you'll be looking for or contributing as we discuss? What should we look to you to, or what would you be looking at?
Well, I have, in my role with the bar, we, as I mentioned, prosecute attorneys, so the rules that Kevin Moore just described, we are the enforcement side of that with respect to attorneys. So we are, since they are now in effect as in November, we are looking more in depth of how they apply in terms of actual practice of law with respect to attorneys. But also with respect to my role here with you, it's just stay in contact with you, and whatever rules that may need to be changed based on our discussion here and evolution of in terms of access to justice, I want to bring that back to my office as well and see how that could apply as we enforce these new rules.
Thank you. Daniel?
I'm Dan Rice. I am the Chief Technology Officer for a company called SageWise, and we are a blockchain smart contract company. I think what got me interested in this is mostly when we started getting into smart contracts, my co-founder is an attorney, a securities attorney, and we realized that we had this issue where a lot of times the code is creating these binding agreements between parties, but the lawyer can't write the code necessarily, so you have multiple parties involved in creating this binding contract between parties. In addition, there are a ton of access to justice issues involved in the smart contract space because a lot of times there is no way to have any recourse when something goes wrong inside of this blockchain smart contract world. So that's kind of where we're coming from. It's very futuristic compared to, I think, where people are actually at right now in the world. But yeah, that's what brings me in.
And where are you based?
In LA.
Okay.
Hi, Alan Rodriguez here. I am based in Los Angeles, Southern California, Pasadena specifically. So I am the founder of 1-400. We're a law innovation consultancy.
Sorry, can you say that again?
1-400, ONE 400.
Okay, thank you.
Quick aside about the business name. In fact, our business name is inspired by Rule 1-100 of the California State Bar, which is the attorney advertising. One of the services that we provide are marketing services. So that's the connection there. So my background, my general interest, I'm not an attorney, but I've been involved in the legal industry for 18 years, north of 18 years. Before co-founding or founding 1-400, I was the director of attorney services at LegalZoom.com. So I created, between 2008 and 2012, I was charged with creating all of their attorney-fulfilled products. And then before that, I was the operations lead at the LA County Bar Lawyer Referral and Information Service. So familiar with that world as well. My interest here is having served on a lot of the committees of the Bar Association and other organizations. You know, there's oftentimes this talk of better access to justice, but not always a lot of action towards that effort. And I really feel that technology has an opportunity to kind of turn that around in a big way. So at 1-400, we provide software and digital experience solutions for law firms and legal technology companies, but our favorite projects are those that actually create better access to justice by altering the business model, say within a law firm, creating recurring revenue opportunities for them so that they're more profitable, but reducing the barrier of entry for the consumer so that they can access justice more efficiently. So we've got a lot of experience in developing those products, and I'd like to contribute on that front.
And where are you guys based?
Los Angeles, Pasadena specifically.
I'm Barbara Arcedo. I'm with the Contra Costa County Bar Association, which, if you're not familiar with San Francisco, we're just on the other side of the bay, a little bit past Oakland. I've run their lawyer referral service and their moderate means program for the past 10 years. And I'm passionate about access to justice. I did work on the commission with Justice Liu several years ago regarding moderate means and limited scope. I'm also, because I run the lawyer referral service, a liaison between the public and our attorneys. And I do believe that technology needs to be involved, definitely, especially in the area that we're in, because where we are, there's a pretty diverse, either low-income or high-income population, and you can definitely see where the help is going for the higher-income clients rather than the ones that have no access, but yet they are some of them are very technologically competent.
Okay, great.
Hello again, everybody. I'm Andrew Cott. I'm a State Bar employee. I'm based here in San Francisco. I work in, typically work in the Office of Professional Competence. Right now I'm on a temporary assignment with the Office of Access and Inclusion, which, as I mentioned, does a lot of the grant-making policy work for the ALTA program and funding legal aid associations and services. I'm here to help shepherd you through this project, beginning to end, and my background expertise is in legal ethics and professional responsibility. And I just, since he's not here, I want to give a quick shout out to Professor Kevin Moore. You saw him give his presentation. You guys are blessed to have him on your team. He's an encyclopedic knowledge of not only this state, but every state, and all their rules and all their nuances to their rules. He's also an extremely hard worker, great note taker, and he'll help you guys tremendously. Oh, yeah, sorry.
My name is Andy Kuchera. I'm a professor at San Joaquin College of Law in Clovis, California. And I teach remedies and a number of practice courses, including community lawyering, legal technology, and law practice management. My passion is access to justice, specifically access to legal representation, with a focus on modest means clients in rural areas. And so we have a number of new things that we're doing at our law school, including a new practice certificate program, as well as a law practice management class that prepares students for independent practice serving low bono clients in rural areas. And we're also starting a legal incubator that has a specific focus of low bono clients in rural areas. So this task force was really a bullseye for me. So I'm happy to be here.
Great, thank you. Justice Edmond, is there anything you'd like to add?
I don't think so. I'm passionate about everything that this commission is doing, and I'll be bouncing around among the subcommittees. But I tell you, just having heard your backgrounds, I'm so excited about the work of this task force because there's such diversity and yet such passion for providing access to justice, literally coming from all the directions that you're coming from. And I'm learning that I have all these new neighbors. I am in downtown Los Angeles. I live in Pasadena, so it's great to get to know you all.
Thank you. Greg?
Well, again, I'm Greg Fortescue. I've been with the Supreme Court for 5 years. Really inherited a lot of the state bar work and spent a lot of time with the Rules Revision Commission over the first 4 years there. Been a lawyer for, let's see, I guess about 12 years, and before that I was in the high-tech industry. I worked for E-Trade for a while. After my brother started a company I was working for that was acquired by E-Trade, I was a revenue operations manager for NBC Olympics for years. And I was one of the founding members of a company called Medscape, which is part of WebMD now. It's one of the few websites that was started in 1994 that still exists, so I'm sort of proud of that. But I just to echo Justice Edmond, it's really exciting to be around a lot of people from such diverse backgrounds, all focused on this one issue, which I think is a very important one. And I know the court is excited to see and hear what this group recommends and decides, and is definitely interested in your work. So.
Great, thank you so much. So I don't know if you saw the list of questions. We have a list of questions to go through. I don't know if we're going to get through all of them, but at the end of the day, we're going to have basically 2 assignments, and later I'm going to ask for volunteers. And the first one is going to be related to putting together basically a list of the answers to our first question here, which is, what are the existing categories of innovative legal and law-related services that are believed to be constrained by the rules of professional conduct? or other lawyer conduct laws. And then the next task is going to be, what's the public purpose of each of these laws? So I think that Kevin is going to, he's not here, but he will be nominated to be have one of those projects. But I think what we need to do is vet the legal services and not just identify them, but really talk about how they work and the nuances, because I think that's going to be the weakness for the people that have proficiency in the rules of conduct and the laws. So if we can figure out and work out the way that these products work, then we can hand over that information to the experts on the laws and the rules who can say, okay, these are the rules that are going to be problematic for you. And then from there, we can work through solutions at later meetings. So I know that the report has a long list of different categories. Let me see if I have that here. Does anyone want to throw one out, maybe one that they, in a space that they work in, that they think is constrained by the rules, and we can start from your personal experience? If not, I'll draw from the list. Okay.
You're talking about, for example, the California RPCs that are constraining the innovation of legal services.
Right, so let's identify the service, the more innovative legal service that is being constrained.
Okay.
And in what way is it being constrained?
Well, I guess the obvious one would be entry-level legal services that are, that could be provided by non-lawyers. I don't know that there's such a discrete distinction between, I guess this would entail a discussion of UPL, but...
The system has detected that a minimum number of lines are connected to this conference. Do you want to continue your meeting? Press 1 to confirm. If there is no...
So I don't know that there's such a discrete difference there, that some of them are maybe legal type services or ancillary services, but some legal services that potentially don't require full representation by a lawyer.
Can you identify a few services that you think of off the top of your head?
So basic corporate formation is one. I have a small practice on the side. That's one of the things that I do. It's fairly straightforward. Most of the time doesn't require the services of a lawyer. But the problem is that everybody's situation is different. And so without a lawyer doing triage, you don't know that lawyer services aren't required. And that's a problem with, I perceive with things like LegalZoom is I don't know that the proper level of triage is there.
Okay. Does anybody else have suggestions about types of law, such as corporate formation, that doesn't really require an attorney if it could be properly triaged?
I think there are like several, but maybe I'm a little confused about what we're trying to accomplish with the answers here, because there are like at LegalZoom, for 4 years I created products that were commoditized versions of, like either attorney fulfilled services or software-based kind of solutions for those. So I'm under the impression that many companies kind of solving these, like business formation is a great one. Like that's one of LegalZoom's #1 selling products, right? Like I think they have 20% of all business formations in California. It's just done by software. So
can we talk about LegalZoom? I'd like to have a better understanding as to how it fits. Is it impeded, or how does LegalZoom really work?
Well, to the degree that I can disclose, and I haven't been there since 2012, so the current I can't speak to the current operations, but I think my job was to figure out kind of a way around the current rules to some degree, to allow like attorneys to sell commoditized versions of their services, or to offer, I guess, a little bit more than do-it-yourself services, right? Like not comprehensive prosecution of a legal matter, but somewhere kind of in between, where an attorney can maybe triage send somebody down a particular software-based solution. So the classic example using the small business formation is people respond to a $99 ad, form your business for $99 online. The first question the customer service rep at LegalZoom gets is like, this is great, which entity should I choose, right?
And this is a non-attorney.
This is a non-attorney,
Okay.
so that's, answering that could be EPL, right? So there's extensive training at LegalZoom to make sure that that doesn't happen. And then, what the customer service rep has to do is either A, point them to a long list of FAQs where the customer can try to figure it out on their own, or after some of the products that we created, can point them to an attorney to get that very specific limited scope advice, and then go buy a LegalZoom product for $99, right? So the attorney could be compensated with, a fee that's paid to them directly or through some arrangement that LegalZoom might have with them. Like say through a legal access plan is one of the products that we created at LegalZoom. So subscriber pays X number of dollars per month in exchange for some limited scope services provided by a law firm that works independently.
But that's an extra expense over the $99.
Yeah. So it's kind of a way where a consumer can get the legal advice that they need, but the convenience and price point that they want, by online. So that's an example, but I guess like there are lots of solutions like that. LegalZoom is kind of the more known brand, right? And so
then the LegalZoom would give you the documents, like a how-to pamphlet for how to set up your LLC, if that's
think of it as an intelligent wizard, so I mean the form in California in particular is like a one-page form, I think, focus in. So name, your name, EIN, like do you want us to get your EIN, all that sort of thing. So it's just kind of like an intelligent wizard, so to speak. Somebody fills that in and it outputs a set of documents.
So in the hypothetical where there's follow-up on what business entity should I choose or some other additional legal advice or request is needed, in that hypothetical, LegalZoom provides the customer or the client a list of attorneys that the customer or client is to choose among, or is it contact Bob Jones, he's next on our list for you to be referred to?
Well, there was a couple of offerings, and one of the offerings was like, this is the law firm that services California because they're licensed in California. This is the law firm that services Texas because they're licensed in Texas. So
in my hypothetical, if I'm the customer, I need more questions, LegalZoom direct me to a single law firm.
Yeah, and within the law firm, they might have 20, 30 different, attorneys that are working at that law firm.
But there's only one law firm that's suggested to me, not a group of law firms.
Under the model that I created when I was there, I think now there's a network of attorneys that somebody might be able to choose from.
Isn't there a rule where, let's say I'm an attorney and I refer Andy to someone and he does a bad job, that can come back to me for giving a bad referral? Is there a rule like that? I know we've been constantly advised not to give referrals to people we don't know personally because we could be liable. What does that fall under?
So there's no rule that discusses the hypothetical you just described. There is a rule about sharing legal fees with other lawyers.
So as long as we don't share fees, I'm in the clear, even
No,
if
you can do it and you don't have to work. It's called, there's case law, Supreme Court case law, which allows for it, Rand versus Harris, and I can refer, you can call me, you're like, I have a property dispute. I don't do property law, please call Andy. Andy's gonna give me $100 for that. We can engage in that, we have to disclose it to you, you have to consent to it, and under the new rules before Andy begins to work for you, and then I can get a cut of that. He can't increase his fee by the virtue of the referral, so that's all permissible. Your question, if Andy does a bad job, the rules aren't gonna talk about that. I may have a malpractice or negligence exposure if I knew Andy was bad, or we had an express relationship, which I only gave you to Andy because I knew I'd get a cut back, not because I thought Andy was a good, incredible person. So that's more common law, case law exposure, not rules.
Thank you for that clarification.
Sure.
Okay, so going
and
back.
the division for fees is 1.5.1.
Okay, so going back to Andy's initial concern and proposal, is there something in LegalZoom that doesn't address what you believe that we need? Or alternatively, what could LegalZoom or those types of businesses be doing better that you don't think is being done?
I'm not sure I have an answer to that question.
Okay, does anybody else have any thoughts on that, Lori?
So I think if I'm understanding the question, our initial question we're trying to find information is what innovative legal services are being affected by the rules right now? I think there's a very wide variety of legal information delivery services versus legal services, and I think that's also important to discuss in these spaces. So these may be places that are already existing that are not providing legal services, but do provide a wide variety of information designed to help consumers. And I see those, even those which are not technically under any, shouldn't be under any threat of UPL, are either being forced out or so threatened that they can't find funding in order to get to the next level. There's actually a young entrepreneur here in San Francisco who developed a program to help you file a California's version, I'm going to say this wrong, sorry, version of small claims for $30. You can go ahead and enter your information and it'll spit out the form and it spits out some information on how to file that. And there are a lot of those type of services available for very small amounts that are hindered because of the fear of UPL or the financier's fear of UPL, so that they're not getting the proper funding. So I'd say anywhere you can monetize a legal form, which in itself the form should not be legal services, anywhere you can monetize those forms are being affected by I think the fear of UPL and the rules themselves.
Would you, sorry, one follow-up question. Would you suggest that if I'm offering a service, a form filling service, that should be overseen by an attorney? Or would you take the position no attorney needs to be involved at all?
So let's see, let me see if I can bring back some of I worked in a law firm at the time. It depends. Isn't that the famous lawyer response? It depends. I think that there are a wide variety. So I'm actually a little rogue. I believe that the courts themselves should be funding and helping create some of these products. I think that if we are truly talking about protecting access to justice and opening access to justice, that the courts could be funding programs that actually decreased people maneuvering the system with no help. So, you know, in Tennessee, for instance, we developed a set of pro se forms. I love my home state, so anything that I say right now should be noted that we have an amazing group who are working on those things. But we talked so long and we worked so hard to develop a 33-page divorce complaint for pro se's couples with no kids and no assets. And it's so complicated that every time I go to a clinic, lawyers ask me to fill it out as a non-lawyer. So I think we have a lot of that, and so there are a lot of forms that are not accepted by courts as well, for fear that they don't entail enough information. And again, that just shuts that door to those type of services to the consumers who can afford to pay $100 or $30 or whatever that is for a form itself.
Thank you. I saw one down here.
Yeah, I just wanted to make a comment. I think nowadays, and I'm coming this as a non-attorney and a product person who's developed tons of products in the last 5 years, that I think the constraints are really on the attorney side. I think all of us product people and all this technologists have figured out all loopholes, and they've been validated by all the state bar lawsuits, right? Like the organization. So I think we're good in terms of like the constraints. What I've heard on the other side is that, like, say if I wanted to commoditize or productize like a guardianship product or something in family law, the attorneys worry about not being able to get out of that case if something goes bad, right? They have to petition the court, and they take it on the chin if it's a flat fee project. So I think the constraints that I'm seeing are more on the attorney's ability to be more involved with the technology companies. And I think the constraints are actually impacting them more. Like LegalZoom is doing fine from a revenue standpoint, right? And because they have marketing power and advertising budget, they're able to go out there and acquire clients at such volumes that they leverage that against the attorney, right? And so, but then the hard part for me in like creating a network that would support some of the products we fill is there's a lot of attorneys that point to the rules saying, look, if I go into a family law case, there's a judge on the other end, they're not gonna let me out. So like, it's really hard for me to define the scope of work and offer a flat fee to that consumer, you know, that sort of thing. So I think from my perspective, the constraints now aren't so much like on the technology side, it's like, how do we eliminate some of the constraints on the attorney side so they can be more involved?
And that's actually something that I was thinking of as well, because you know, they have some products for estate planning where you can put it online, people can fill it out, and then I'm thinking, well, what if they don't do it right? Am I, as the attorney, going to be liable? You know, California, our courts definitely don't have the funding to be offering these types of services, but I might, you know, my firm might, or larger firms might, and they may even profit significantly from it because they're going to have so much volume. But the concern then is, well, are they going to be liable to every single one of those clients that uses the form through their website? So I think that needs to go in the notes about, you know, limiting liability to attorneys that are offering these types of services. At least then the attorney would have oversight, but, you know, they can only do so much.
So if I could clarify what you're saying, I'm sorry, I didn't, but is the concern that like if the technology goes bad, like say it gets hacked or something, then the lawyer?
Just to provide you an example, if someone comes to my website, I do trust and estates, so a lot of times people have no idea what they don't even know at all what they need. So they come in and they say, I need a will. If they were to just go to LegalZoom and say, I need a will with no follow-up, they might get a will, but that may not actually protect them and do what they think that what they are intending to do, which is protect their estate. If they come to me and say, I need a will, I respond, do you have real property? They say yes. I say, you don't just need a will, you need a trust. If they insist on a will, I say, no, I'm sorry, that's part of my business plan, I don't do just wills. I do estate plans. You need a full estate plan, and I can offer you the whole package, but a will is not going to be sufficient for you. My concern is if I offer a product on a website and somebody comes and says, I need a will, and I stay silent because that's running on its own, you know, I'm not engaging with them directly. Have I committed malpractice by not properly advising them that what they really need is an estate plan? But maybe an AI service could say, do you have real property? Do you have children? If so, you should have these, you know, in big bold letters, and if you ignore that anyway, that's on you, and you've been properly advised. Wait, I think Greg had a comment.
Alan, you're right. I think most of the constraints are on lawyers because the rules, I mean, how many rules do we have? 70.
70.
So we have 70 rules, and that doesn't even take into account the State Bar Act. There's a lot of traps for lawyers, a lot of constraints on lawyers in terms of what they can do, the services that they can partner with non-lawyers to provide to the general public. But you are constrained because it's a misdemeanor in California to engage in the unlawful practice of law. Mm-hmm. So even if you're not a lawyer, you are subject to prosecution. The reality is those crimes aren't prosecuted very often. So I think a lot of people just take that risk into account. What the state bar's role in that would be if there was they became aware that a non-lawyer was engaging in UPL, is to refer it to a prosecuting agency, either the Attorney General's office or to a local prosecutor. And then they decide whether or not they're going to prosecute that crime or not. But lawyers are the ones that are being regulated by the state bar and by the court because they are officers of the court. And so in terms of the self-help, the California courts are engaged in that. There are a lot of self-help programs that are happening in a lot of Superior Courts right now around family law. But as you can imagine, and through equal access funds that are appropriated by the legislature and jointly administered through the Legal Services Trust Fund Commission and the Judicial Council. But it's a limited number. I mean, the courts are underfunded. That is clear, and they have been underfunded for quite some time. So I think the court is really interested in ways in which it can unleash the commercial sector to help, and while at the same time protecting the public and through regulation of the attorneys, which is its job. And so I think a helpful way to think about this is ways in which companies can help lawyers do their jobs more efficiently, which during the presentation on the report, Professor Harrison's report, that one of the reasons I was focusing on the number of hours that are being billed on a daily basis by lawyers is because I'm wondering, what are they doing with all those other hours? I know he said that they're looking for other clients, but what kind of clients are they looking for? I think there's an assumption if we can just free them up from having to market themselves, that they will lower their rates and be able to serve more clients. That may or may not be true depending on the type of practice they're engaged in. But the way I'm looking at a lot of these services are, what are the services that are going to help the lawyers do their jobs more efficiently and hopefully allow them to offer legal services at a lower cost to clients? And what are the services that people can at least start the process on their own and get to a point where they're further along, where when they need a lawyer, they are only looking at 10, 15 hours of time that they need. It reminds me of a friend of mine who did go through a divorce, did not have much money, and he really moved, and it wasn't acrimonious, thank God, and there were no kids involved. So he was able to really move the process pretty far down the road before he had to bring in a lawyer to just check all his paperwork, make sure his filings were in order. But he's pretty sophisticated also, and he was able to figure that out on his own. I don't know how it's a challenge, I think, for companies that are trying to find ways of partnering with lawyers to provide products to the general public. When I hear some instances of companies that are finding it challenging to operate within this regulatory environment, I start to classify them in my mind. Those problems that they perceive with the rules that from where I'm sitting, doesn't seem like a problem. Those that do touch on some sort of gray areas where perhaps some revisions to the rules would be helpful to provide additional guidance. Because one thing that Mark Tuff will tell you is that the purpose of the rules is not only to discipline attorneys when they violate them, but more often than not to provide guidance to them so they can conform their conduct. And most lawyers want to comply. They don't want to be in this building, right? They don't want to be drawn into state bar court. And so they're looking for guidance. And they're going to be, if you're a good lawyer, kind of conservative when you start flirting to what they consider to be the edge of unethical conduct. And so I think what we're trying to do is just sort of flush out those instances, and maybe the best way of approaching is companies that are engaging in this kind of activity that may be concerned that they are flirting with the edge, or companies that have ideas but they perceive the rules as providing serious impediments to them, and figure out ways in which either the rules could be adapted in some way, or there may be instances in which we say they can't be adapted because this rule serves an important purpose. It protects the public. And I don't think the court is interested in moving down a road in which they feel that a lawyer's independent professional judgment is going to be compromised more often than not. So I just say that because I think, I hope that's helpful in some way. I know we could look at LegalZoom and all these things, but to me, I'm sitting here, I know some of these companies, I don't know others. I just want to have a clearer sense from the group eventually of what are the areas in which the rules really provide a serious impediment, and really try to break that down and see, is it a true impediment or is it a perceived impediment?
Tara, can I make a recommendation? Because time's up.
Oh, at 4 o'clock?
Yes, we're done at 4.
Oh, no.
So.
I thought we had till 5.
No, so I think it would probably be helpful if you make the assignments so that these folks can work on these issues. I mean, as I see it, number 1 is what are the existing categories of innovative legal and law-related services that are believed to be constrained by the rules? And 2, what are the public protection purposes of each of those rules and laws? They kind of go together. I wonder if it might be a good idea to put Professor Moore on both questions and then somebody else to pair with him.
I agree. And I would like someone to volunteer who knows the innovative techie side, at least 1 or 2 people, to come up with these existing categories. And then if we can do that in the next few weeks, we could properly share that list of categories, and feel free to put all your thoughts, and then we can have it go to Professor Moore maybe to further vet and identify the rules that are involved in the public protection
Is
purposes.
it just existing or is this potential? I think
It would be potential. I mean, we're looking at just the categories, so I think we've just barely touched on them, but we've sort of identified it kind of, I don't know, I'm not sure what we've identified, the kind of the do-it-yourself / information services. Just quickly, I will go through some others that are in the report. Document drafting, self-help resources, access to legal information, prepaid subscription services, dispute resolution services is really outside of what we touched on, but should be included. And I think there's probably a lot more in that report that would be a good guide, plus anything you're aware of in the industry. So do I have volunteers for that?
So, Alan, let me just, no, I'm not going to do
I'm happy to.
Yeah, I think Alan has a lot more connections in that area. I'm happy to help and support.
Okay, if you guys take that on.
No problem.
No worries. Thank you. So our next meeting is the 9th, or the 19th of January. 18th, Friday. And so we kind of need, do you think that by the end of the year, you could have something? I mean, ideally, if you could do it like in 2 weeks, like by the 21st before Christmas, and then we could turn that over to
And this is
Professor
just
Moore.
a list with maybe website. I mean, how much information, I guess, how much information are you?
Well, he doesn't have, this is not his strong suit, right? So the more information, I mean, I think we need a list and a list and then identify what it is. So the list really would not be the companies, the list would be the categories, or what you perceive to be the categories. And as bullet points to that list might be examples that we could all look at, because I would love for us to be able to share that list and for us to check out the websites. I was like Googling all your companies while you were explaining them. So we can sort of see what they look like and get a feel for them. Otherwise, it's all very abstract. And then your perceived impediment. And then we'll just pass it on to Professor Moore for his thoughts and comments in response to what you have. And I think that will be a good starting point given our limited time today. And then we'll be able to circulate that well before the meeting. And so hopefully everyone can, spend a couple hours before we meet again, sort of digesting the various products out there. Does that sound good?
Okay. Yeah, I don't want to speak for Professor Moore, but I'm confident he's probably included most of them. There are a few, I would add, he's going to know the rules and the law that are constraining, I think, which would be helpful, and for anyone around the table, but those who are in the fields, just to identify the products, the services, and whatever else that's unknown to the rest of us that are available or you were aware of and have since not been developed because of rules that might have constrained them. Anything, even just a brainstorm session, even if you think it's too too wide of a gathering of ideas. Let's start big and then we can narrow them down. I think that would be in my view, that would be the helpful task that the non-lawyers around the table or the people in the industry could provide.
And if you know the companies and you want to reach out to them for a comment, hey, why do you believe your company, what were you afraid of? And that's something we can do later. Don't feel pressured to do that over Christmas, but I'd like to know what were they actually thinking. Why did they feel like they failed or that it was an impediment to them? And then I'd like to ask just everybody else to, if you could submit something to our staff with something that you've observed as an impediment that we didn't get to discuss today. Let's get that in writing so that we can digest it at the next meeting and have that information to work with.
And can you one more time restate the question for us?
What are the existing categories of innovative legal and law-related services that are believed to be constrained by the rules of professional conduct or other lawyer conduct laws? But in addition to that, my second request is, what is something that you believe has been restrained either in innovation or offering access to justice that these rules could better address? And it sounds like just clarification might, go a long way for some of these things.
And this information, is this in Dropbox as well, the initial
The
question?
report, no.
If it's not, we can add it.
I can add it.
I don't know that it is, but I'll ask Mimi to add it.
It isn't because I just came up with it.
Oh, the second one?
The second one,
Yeah,
yeah.
it definitely won't be added.
The first one is, you
That's
can
your
get
Dropbox.
added. And then, will you say your second question one more time?
Yeah. The second question is, any issues that you're aware of or have experience with, regardless of whether it has to do with tech or innovation, that you see as an impediment to the access to justice that could be addressed through changes to the rules of professional conduct or other lawyer conduct laws that are along the same lines that we've been talking here today. Basically, I just want to get a feel for what, your ideas are, because maybe there's a way it would tie in, something that, we're not addressing directly. I don't like to limit things.
Makes you a perfect chair.
And then the rest of us should submit these to...
So to Mia Ellis, who's your primary staff person, but please copy Mimi Lee and Lauren McCurdy.
And where can we get these email addresses? Do we have them in?
Sure, so everyone has the same format. It's so for Mia, it's MIA dot Ellis, ELLIS, at calbar.ca.gov. And under the same formation, it's Mimi Lee, MIMI dot Lee at calbar.ca.gov. And the last helpful staff person would be Lauren McCurdy, LAUREN dot MCCURDY at calbar.ca.gov. And, send them to us individually, we compile them and we'll send them out to you, and that helps avoid any of the back leaking questions that we review.
But Alan and Lori, you can communicate directly. You just can't send stuff out. So one of you would send.
So once we have our list, then we send it to these email addresses for greater distribution.
Correct.
Yeah.
Okay.
If you want to send us to us individually, we'll compile them and have one list that represents your subcommittee's thoughts.
Yeah.
Okay.
And then, this, I'm not trying to rush you, but the sooner you get it to us, when you send it over to, no pressure, when you send it over to the professor, if you could also distribute it, because other people may be able to contribute to it further.
Okay.
Yes.
That'd be great. Thank you.
Thank you all so much. Travel home safely.
Thank you.
Can I clean up the notes and then email them to
Yeah.
who? The same.
Yeah,
same
Mimi,
people? Okay.
Mia, and
Yeah, I
Lauren.
want the rest of us to submit by the 21st? Or is that just for?
Oh, you
Yeah,
took meeting
whatever.
minutes?
Just for Lori and?
So help.
Yeah, just for them, so that they can get it.
Okay, so what do you need from us?
Whatever,
Oh.
in advance of the
Oh,
next,
Yeah.
in advance
Yeah,
of the next
that was
10-day
around
notice
for
period.
3-4 years.
So in advance of the 9th,
Oh,
so
yeah.
that it can be distributed.
Sounds good.
Yeah.
I'll be working with you, you mentioned that.
Yeah, he was over at
Have to
Rocket.
get better at calculating dates here.
And they were building out a legal plan as well. Yeah, he's a great guy. Where do you land?